List. Daily list for orders, item 1.
Lordship, in these two reviews, my senior, Mr. Kalita, would like to address this court on the delay issue. So, and a similar matter has already been fixed, but not by this bench, on 13/12, here on the delay issue, Lordship.
13/12.
Yes,
13/12.
Lordship. But I'm not sure if it is with the same.
No problem. If it is on 13/12, we'll hear on 13/12. They say that's delay if it is similar. 13/12, 13/12.
That may be done, but case should be had individually. my lord.
No problem. We'll hear it.
I'm not saying
Every
annual
case has
August.
its own
Yes,
merit.
Correct. Absolutely. We'll do that. At least the principle what to follow.
Yes, exactly, Lordship.
Okay. As prayed by both the parties, matter be listed again on 13 now, December.
May please, your lordship. After for listing my lord, motion my lord.
Fresh case.
First case my lord.
Acha, next week.
My lord.
All next week, all mention next week. Next. Chalo. All mention next week. Yes, anything adjournment you want?
I beg to mention item number 16 from the daily copy.
What do you want?
I beg to mention item number 16. My
What do
senior
you
is out of
want?
Station.
So your
Madam,
adjournment?
Adjournment, Your Honor.
Okay, on the Prime Minister Sen. In National Education Society 2022, read appeal.
Read appeal, Your Honor.
What is your name?
S.K. Gupta,
Mr. S.K. Gupta, mentioning on behalf of
O.P. Bhatti.
O.P. Bhatti, Learned Counsel for the appellant. Submits that the matter be adjourned on account of
He is out of station, Your Honor.
non-availability of the
Non-availability.
conducting counsel. Praise the Lord. List accordingly on when?
After 2
January?
weeks. After 2
22
weeks.
Next year?
After 2 weeks.
After 2 weeks means next year. Next year. List next year. Likho. Next.
Daily list for motion, item 1.
Jainul, yes, tell us quickly.
Lordship, in this case, earlier this honorable court, by order dated 14/6/2022, was pleased to remand back the matter to the tribunal for fresh
Yes. Continue.
fresh opinion, Lordship.
Then?
Thereafter, in a very mechanical manner, Lordship, the tribunal did not go through the order of this honorable court and passed the impugn order, whereby again the petitioner has been declared a foreigner. And the impugn order is at page 96, Lordships. 96, page 96. Wherein the learned member has made some trivial observation. That is page 97, maybe Paris Lordship. The last paragraph. Last paragraph, 4th line. Now, if I consider the petitioner OP to be a resident of
Just last
Yes.
time, page 97.
page 97, Lordship, last paragraph. That is numbered as
While
1. That is while the OP side has nothing to say much in favor of OP's Indian nationality, the tribunal has decided to forward its view, fresh view as follows. That evidence says that the OP is really a resident of Bhazakhaiti Gao, but his father's name is there in the voter list of Bhazakhaiti Patha. It may be mentioned that Bhazakhaiti Gao and Bhazakhaiti Patha, two different revenue villages. Now, if I consider the petitioner OP to be a resident of Bhazakhaiti Patha, although the OP said himself to be man born at Bhazakhaiti Gao, even then the OP MD Zainaluddin, son of so and so, cannot be an Indian citizen. He cannot be declared to be Indian person by a fresh opinion, while the referral authority has mentioned an address of the OP in Bangladesh in reference as follows. So he relied the reference wherein the address of the OP is in Bangladesh. Thereafter, page 98, Lordship may be perused. The above mentioned address of OP in Bangladesh has made me strongly ascertain that the OP MD Zainaluddin can no way be an Indian
what is this?
And
Then of
thereafter,
course we'll
Lordship,
say, if that is so, then what is the purpose of a tribunal? Tribunal has to say that, reference me that he's from Bangladesh, so declare him. I don't think this is the correct view.
and thereafter, Lordship, he has also
Monday, we'll hear on Monday. Come prepared on list the motion again on Monday.
Lordship, some more.
Monday,
time.
Monday,
Lordship,
sorry,
one
you on
copy.
only on law, there's nothing to do, we don't know what tribunal has done.
Tribunal has
This
not
is
produced the order of the.
Nothing, tribunal has done
Honorable
nothing, tribunal has not at all reappraised, just kicked out the order of this court,
Lordship.
Monday, we will hear on Monday.
Monday, Tariq.
Item number 2.
Monday.
Yes.
after Your lordships. My lord,
Yes, yes,
First, a notice was issued to me in FT case number 1408/2016.
yes,
I appeared, I filed my written statement and it's in the further evidence stage. Subsequently, I received another notice. And
Hmm,
so I'm challenging the second notice. First case is pending, another notice I have received, lordship.
sorry, you have challenge and in the challenge before this court.
No. Before this court, the second notice, lordship.
Uh-huh.
Because second reference, because one reference is pending. Now I have received notice from another reference. So I have challenged the second reference.
Okay, let us see the first reference, let us see the notice.
Notice
first,
is at page
page.
22, Lord.
Page 22.
Yes, Lord.
YS Ali, this is the first reference.
Yes,
Now
Lord.
it is pending,
Yes, pending.
pending before the foreigners tribunal.
Yes, Lord.
Okay, and second reference, let us see,
Second reference, Lordship.
page.
Second,
Page.
page 62 is the order sheets.
Page 50,
Page 62,
page
Lordship.
62.
22 are.
That is another reference, 1833 of 2000.
But the name, we want to name the name. Is the same as YS?
64.
We want to see the particulars, huh? 64 is a foreign tribunal name, Assam,
Name is
claim.
different, Lordship.
Name Wasis Ali, son of late Hussein Ali.
Hussain.
And village,
Village is same,
Langia.
police station is same, district is same.
Hmm.
Say, okay, notice to Nikalu to second notice.
And the
Lordship,
first reference you have challenged, what?
No,
no.
first reference,
It is
I'm
pending.
contesting. Yes, I'm contesting.
Then
that.
you will keep in the same, they will say that both these references be hard together.
Together. Yes.
Yes,
Lordship.
Lordship.
Because if you are claiming the same,
Yes, same.
you are referring the same.
Same.
Documents are same,
Ah,
everything
ah.
is same, and if the person, because he
Okay.
has come to this court, that means
Yes,
he's
yes.
accepted that he is the same person.
Same person.
So both the
Let him-
references may be heard together, Lordship.
Okay.
Yes.
We will club
Yes,
together.
Lordship. And there is another one notice I have received that I have challenged in another writ petition, which is not yet listed. That another writ petition, and from Jorhat, I received another notice
Same
that I have
person.
challenged in another writ
Same
petition.
person.
Same person.
So Lordship.
So
when-
let this
when
be
that matter
pending
is
and that
listed-
matter be listed, Lordship.
When that matter is listed, both the writ petitions may be taken up together and
Yes,
orders
Lordship.
may be passed on that day.
Okay.
Yes, Lordship.
Because one
Okay.
person receiving three notices
Correct,
from
correct.
3 districts.
Okay. And you have filed a repetition noted,
File,
the
Lordship.
third also,
Second writ petition also already I have filed.
but number you have got, no.
Number I have not. yet.
Okay, then let's on Monday then,
Yes, Lordship.
Huh?
Yes, Lordship.
list this along with WPC number.
Not
That is
listed.
not yet.
No, earlier this,
This is.
first you have not challenged that one.
First, this one is the
Page
first.
22 is going on, you have not challenged.
No.
Okay, list, okay, huh? Okay,
This next week.
okay, next week,
Yes,
list
Monday-
this again, huh? Monday when?
Monday, Lordship, and so that by the meantime, I will.
Hmm. List along with the petition file, do you have the filing number?
I'll just check the filing number and I'll provide.
Okay,
the
list
filing-
on Monday then,
Yes, Lordship.
list on Monday,
Yep.
next.
Item number 3.
May it please your lordship. Lordship, the impugn order here is on page 36, your lordship. If your lordship move on to page 37, the order indicates that the notice was issued against the against the petitioner, doubting her as a citizen of 1966-71 stream, your lordship. But subsequently, your lordship, she was declared a foreigner of post 1971 stream. So your lordship, the learned tribunal has traveled beyond the reference, your lordship, in this case. Your lordship.
Okay, we'll call for the record.
Examine.
Notice record interim.
Yes,
Yes.
your lordship.
Item number 4.
Nibaron. Yes, Nibaron.
Actually, this case was petitioner's father lordship appearing to India in 1956.
Appeared. Other
Lordship.
appeared.
He entered India
Enter-
lordship,
Enter in 1956.
56.
This certificate, refusal.
Lordship.
It was produced before the tribunal.
Lordship, it was for you.
Then what did the tribunal say?
Lordship, tribunal says, there is lordship some mistake in the name lordship.
What
In
kind of
some way-
mistake?
Yes. In his original name is Nibaran Chandra Sarkar lordship, but in
Ah.
other photolis and all, lordship, his name is recorded as Nibaran Sarkar. So Chandra is not there. And second thing is that lordship, his father used to write lordship as Kamini Mohan Bepari.
Ah.
Subsequently, lordship, by swearing affidavit, lordship, he has written his name as a Sarkar. So this is the
From
difference.
Bepari to Sarkar.
Yes, sir. And in that aspect, lordship, an affidavit was also shown by this petitioner in 1998. Sir.
Okay, we'll examine, then we'll call for the record.
Yes, lordship.
Ah. Notice record interim. Yes.
Lordship.
Item number 5.
Obliged.
Mohammed Jahur Ali. Yes.
Lordship. May it please your lordship. Lordship, in this matter, your lordship, my grandfather's name appeared in the voter list of 1966-71. My father's name appeared along with me. My uncle appeared before the tribunal and deposed that I am his nephew.
Examine, lordship.
Notice record interim. Yeah.
Item number 6.
May I please, lordship. Lordship, a very small issue, lordship. Lordship, my name itself is in the voter list of 1971, lordship, and with my parents, lordship. My father's name is in the 66 also, lordship. Lordship, I submitted the documents, lordship, and Douglas also submitted, lordship, and evidence of detail 1 might have been submitted, lordship. Therefore, lordship, the issue is, lordship, regarding further evidence, lordship. After, lordship, only passing 2 dates, lordship, the case put into expertise, lordship. And
Expertise.
expertise, lordship.
When was the expertise?
Lordship, the
Page-
page, lordship, 71, lordship.
Page 71.
47, lordship, sorry, 7,
Page
4,
71.
71, lordship, when I say 18.
After receiving the establishment appeared before tribunal after taking several joint parents submitted written statement on 19 and due was
The
for
written portion will be
submitting.
72
We
number
know
2.
submitted evidence in chief. When that reverse customary and fix for submitting for taking action of the term till then. Now you from the page from that after further evidence in absence from 29/1/22 till date without any step.
So, step was there, lordship, but there is
Till
findings
without
wrong.
any step. Although Lama has said taken some prisoners for rejected on from the appears the delaying. So you are delaying
Delaying
tactic.
without
So,
taking steps.
2 days, lordship, that's I have another.
You have given your DW1
Yes, lordship.
cross examine.
Yes, and cross examine, lordship.
And how many witnesses you are supposed to examine?
So, at least only 2, lordship,
Two.
no more, lordship.
Okay.
So that may be allowed, lordship.
Yes, Verma, let it be allowed. Huh?
Yes,
Yes,
lordship.
But be careful. This
Yes,
thing,
lordship.
okay?
Within this
The
10,
tribunal cannot keep waiting for you. You know,
lordship.
there are thousands of cases pending.
Yes, yes.
You have to be more careful because otherwise you will be declared a foreigner. You have to go to Bangladesh.
Yes, yes, lordship, that's correct, lordship.
Lordship, for further evidence, he has sought time from almost more than a year, lordship.
No, 2 days, only 2 days, lordship. I
No,
don't
not 2 days, lordship.
So,
From
so we'll make an observation that that you should not take undue.
Yes, lordship,
Adjournment.
that's correct.
Ah.
lordship. And the next day, lordship,
Don't take adjournment without valid
Lordship,
without
we can tell
assigning.
about the Cost, lordship.
no,
Oh,
lordship,
A small cost will make them
Kalumia.
more accountable,
what
lordship.
are you doing, Kalumia? What is
Labor,
your
lordship,
profession?
actually labor, lordship. He cannot, lordship, actually, there is some lordship with lapse, lordship. He cannot pay the council, lordship, that's all, lordship, but the council also took time, lordship.
Now this time, how will he pay his counsel now?
Lordship, at least 500, 1,000, I will pay, lordship, that's why, and he'll do the. He has no capacity,
It
lordship.
was just a suggestion. I'm leaving it to lordship.
Very poor person, lordship.
Okay.
It is only to make the procedure accountable, that's all, lordship.
Hmm.
So that they appear and they complete the proceedings.
And Mr.
As hope, lordship.
Let's have learn a counsel for the petitioner, also learn a counsel for the state. Considering the nature of this case, we have the view that the present petition can be disposed of at this stage without calling for records or issuing formal notice. in this petition, the petitioner challenged the order dated 7/4, ex parte order dated 7/4/2022 passed by the learned foreigners tribunal, by which the tribunal, in view of the absence of the petition proceeding on the dates assigned, without proper reasons, proceeded ex parte and declared the petitioner to be an Indian or a foreigner, to be a foreigner of post 25/3/1971. Next para. It is the case of the petitioner that it is not that the petitioner was deliberately avoiding the process. In fact, on receipt of the notice, the petitioner duly appeared before the tribunal and filed his written statement, and also have been adduced evidence by examining himself as DW1, and he was also duly cross-examined. Unfortunately, because of various reasons, including financial hardship, the petitioner could not appear on some of the dates, resulting in delay in the proceeding, which made the learned tribunal feel that the petitioner is deliberately delaying the proceeding. First off, we have gone through the judgment, impugn order. It has been gone through judgment, impugn order. There is in the impugn order, there is reference that the learned tribunal has recorded the presence of the proceeding on after receipt of notice and filing of statement, as well as the examination, adducing evidence is DW1 by the proceeding and a cross-examination on several dates mentioned in the order. However, learned tribunal took the view that after that the petitioner had remained continuously absent from the absent before a tribunal from 29/1/2022 till the passing of the order on 7/4/2022 without any steps, and as such, it appears that the proceeding deliberately delaying the case without any reason. Full stop. Under circumstances, according to the learned tribunal proceed ex parte. Full stop. Next para. Mr. Learned Counsel for the petition has earnestly submitted before the court that since the petitioner has already filed his written statement and also started adducing evidence, he may be given another opportunity to appear, in which his earlier absence on some of the dates were due to reasons which were beyond his control and also because of financial hardships. So, having considered having heard the learned system, Ms. Verma, however, submits that the petitioner has to blame himself for the situation in which he does not seem to have taken the proceeding very seriously. Full stop. Having heard the learned counsel for the parties also consider the matter on record, we have the view that since the petitioner had already started taking steps for steps to discharge his burden, proving that he is an Indian, not a foreigner, and though some lapses can be seen, we have the view that in view of the undertaking made before this court, that the proceeding will henceforth be more careful and will not seek adjournment unnecessarily without valid reason. We are inclined to grant another opportunity to the petitioner to appear before the tribunal to adduce further evidence. Accordingly, for the reasons discussed above, we allow this petition by setting aside the impugn ex parte order 7/4/2022, and the petitioner will appear before the tribunal for adducing further evidence without any further delay. Full stop. And will cooperate with the tribunal for expeditious disposal of the proceeding. Accordingly, the petition stands allowed by the petitioner will appear for the tribunal. Tariq, when?
January, in the month of January, lordship, any date.
January date. Give a date. It is convenient to you.
Within a month.
Within 1 month, lordship.
Within a period of 1 month from today.
Yes, sir. Hello, lordship.
Item number 7.
Please, your lordship. Lordship, from the order also, it is also a case where your lordship notice was issued, doubting the petitioner to be a foreigner of 1966-71 stream. But subsequently, your lordship, the petitioner has been declared as a foreigner of post-1971 stream. So again, the learned tribunal has traveled beyond the reference in this matter.
We'll call for the record,
Yes,
notice
lordship.
record interim.
Item number 8.
Well. My lord, in this case, the petitioner earlier declared as foreigners. And he challenged that order before this noble court. And this noble court remained back the matter, directing the tribunal to take a free decision after considering the evidence and oral evidence, etc. Then my lord, petitioner appeared before the tribunal and submitted an application. The petitioner earlier litigation, he produced some new documents before this noble court, where his name appeared along with his father, but that certificate copy at that point of not furnished to the petitioner. Only 1970 voter list has been furnished to the petitioner containing his name only. Then, my lord, I filed a petition with a prayer to allow me to produce those documents. That petition has been rejected, and thereafter, finally the petitioner again declared as foreigners without considering the oral evidence, evidentiary value. of-
We'll call, we'll examine the matter. Notice record interim.
Item number 9.
Yes, yes.
Lordship, here, contested case, my lord, petitioner has been declared as foreigner of post 71. Lord, his father, her father's name appeared in the, her grandfather's name appeared in the voter list 1960, 66, 71. Father's name,
Examine,
Notice
lordship.
record, notice record interim. Yes.
my lord, SP South Salmara Mankasar.
South Salma one. Yes.
Item number 10.
Sahabuddin.
Your lordship. May it please your lordship. Lordship, here your lordship, the petitioner's father's name appeared in an NRC of 1951, voter list of 1966. His name appeared along with his father's name in the year 1977.
Examine,
I mean,
lordship.
there is some variation of names, your lordship.
Notice
Sahaba is
record
Sahab.
interim, we'll examine.
Lordship.
Notice record.
Item number 11.
Asia Khatun.
Lordship, in the earlier case, your lordship, interim maybe,
Interim, yes.
your lordship. Lordship, in this case, your lordship.
Arya Khatun or Asia Khatun?
Asia Khatun, lordship.
Okay.
Your lordship, here also, your lordship, the petitioner's father's name appeared in the voter list of 1966-71, your lordship. Your lordship, 1965, your lordship. And your lordship, here, he has also exhibited a line document, your lordship, in the name of a father, your lordship, 1964. your
Notice
lordship.
record
Our elder
interim.
brother also appeared, your lordship.
Item number 12.
Sona Bhanu.
Yes, please, your lordship.
Yes.
Lordship, the petitioner before your lordship is declared as foreigner by the opinion dated 11/3/2022
Mhm.
by the honorable member for the tribunal Bongaigaon number 2 of our lordship.
Yes.
Lordship, the petitioner was born and brought up at village Thoralipara Part 2
Hmm.
under Obhorapuri, where her parents and grandparents are permanently settled.
Hmm.
The name of her father and mother are recorded in voter list of 1966 and 1970, lordship.
Hmm.
Kindly see page 18 and 20, lordship.
Hmm. Yes.
Her father's name is Monuruddin and mother's name is Jamila Khatun, lordship.
Hmm.
Her name of the name of her father, mother, brother, and other family members are reflected in voter list of 1989, 97, and 2017, lordship.
Hmm.
Lordship, since the petitioner got married before 1985,
Hmm.
some about 40 years ago, at the age of about 19 years, to one Taizuddin, village Noravita Part 2, under Maresar Bongaigaon, lordship. So her name is not reflected in any voter list of her birth village,
Hmm.
along with her parents and other family members, lordship. So she, after her marriage, she applied to register her name in voter list of the year 1985.
Hmm.
But her name for the first time appeared in voter list of 1989, lordship.
Hmm.
And her name is also reflected in voter list of 97 and 2017, lordship.
Hmm.
Kindly see, lordship, page number 27,
Hmm.
29 and 30, where it is reflected her name.
Hmm. So the government, so the state is saying that your name is recorded after 71, so you are a foreigner.
Lordship.
The state is saying that since your name is recorded after 1971, 1981 only, therefore you are a foreigner.
No, Lordship, actually, because she got married about 19 years age, before 1985. So her name is not reflected with her parents and.
And what is your parents' name? What is your parents' name?
Parents' name, father's name is Monoruddin and mother's name is Damula Khatun, Lordship.
Their name is recorded in the voter list in
Yes,
India.
Lordship, yes, Lordship.
Have you stated that in your tribunal you stated they are your parents? And what did the cross-examination, in the cross-examination, was any question asked?
She also filed WS with 11 number of documents, but
What is this will, which is more?
oh, Lordship, kindly see page number 32.
What is this will?
Her father executed a will during his lifetime in the name of the petitioner and her brother and sisters, Lordship.
Oh, what did you get as per the will? Did you get anything?
Lordship, the will was executed when the proceeding was going on, Lordship. When
No problem. He can always write. He can write a will before he dies. Anytime.
linkage document is not there, Lordship.
No problem. When the will he can write anytime before he dies. And will is something like a kind of deposition. His statement that, what is your name?
Sona Bhanu, Lordship.
Sona Bhanu. I tell him, Sona Bhanu. So you got how much? I have will 4 bighas, 2 kathas. You are a very lucky woman. Normally, women do not get any property. Only male get. Normally. Huh?
Now it is changing,
It's
Lordship.
changing, correct?
Parents have to change their mindset.
Yes. They now started giving property to their daughters. Earlier, only male used to get. Of course, among the Hindus, because of the Hindu Succession Act change, they were getting early. Huh? They have also 1956? No? 50?
54.
54. Before that, women didn't get. The Muslim community also they have started giving. But as per law, I don't know what is the personal law.
Now all children are entitled to
But
a
as per
share.
Muslim personal law, do the women get? Do they have a share in the?
Yes,
Huh?
180. 18.
18. And another personal law. 18. 1/8 of the share. Oh, this year also, he is only getting 1/8 or what? More than that? Equal. Huh? So if it is only will, then you got more than 1/8. 1 bigha. Huh? 4 bighas, 2 kathas, 2. How many? Son and daughter. How many son and daughter? Oh, 8. 8. So 4 bighas will be half bigha each. Huh? At least you are getting equal. Son and daughter are equal treated. Very good. Is a registered will also. This men will not give to somebody who is a foreigner.
Lordship will
So
examine
it shows
that.
you are Indian. This will.
But the father is real or
I will never
projected.
give my property to a foreigner. Unless, yes, father.
So if he's the real father or a projected
Real father, whether real, you mean to say that some unreal father will give property?
But that link document is.
See,
not
Verma,
good.
there is one thing. Statement deposing in the tribunal saying that she's my daughter is one thing because he doesn't give anything. Just statement. So you may say, well, he has hired this man to say, depose in the tribunal that yes, cock, a tribunal koidiok, that you are my father or that I am his daughter or something.
Was the father when he executed the will, Lordship? I am just trying to.
70, 80-year-old. Currently 70, 80 years. He also done, he is illiterate. Andas. Everything is by andas. And illiterate people, they said, I mean 70, 80. 10 years difference.
I say less. They
वो
will never
बोले
say-
70,
they
80 हो पा रहे.
never go more than 40, Lordship.
So at
Because
least
not
he's
even
a very, very religious old man is giving equal share to son and daughters before he dies. And that proves also that otherwise why should he give to this woman if she is not his daughter? If eight daughters, why should if it is, see, eight, no? One son, Munjan, all daughters are what? How many sons? Abdul.
2 daughters.
4 sons and 4 daughters.
2 daughters.
4 sons, 4 daughters,
Yes, sir.
8 children.
8 children.
8 children.
So we'll examine it. Okay, records, notice, record, interim. What is your name?
Embora.
Embora. Bihar Embora Lane Council for the petitioner M also. Notice, record, interim. Yes.
Item number 13.
Noor Bhanu
May I please,
Begum.
Lordship. Lordship, the petitioner's permanent resident is in Thuburi district, Lordship. In the year of 2012, she went to Nazira village for earning of her livelihood, Lordship. And
Earning her?
livelihood as a daily laborer, Lordship. And then she suspected as a foreigner in the same district, and the same is reference is pending in the foreigners tribunal, Jorhat, Lordship. And now, as she is a permanent resident of Thuburi district, she come back to Thuburi, Lordship. And now she cannot afford to go Jorhat and contest the case, Lordship. This is my simple case, Lordship.
Lordship has already
Her name has been recorded in the NRC,
Lordship has
Lordship.
already heard the transfer matters and the judgment is awaited. He's seeking for a shifting of the
Lordship, her parents' name in recorded in the voter list of 1960. Her name is
Is
recorded-
the proceeding still pending?
still pending, Lordship,
Okay.
and she cannot afford a
List the matter after disposal of the again naam to ki thi?
transfer matters.
Aase of disposal after the this is the matter after disposal of the WPC number showing analogous matters.
Jonglu Ali, WPC 7
Jonglu Ali, yes.
WBC number
7309 of 19th.
In the meantime, the proceeding pending before the learned foreigners tribunal in Jorhat in FT case number
FT case number FTSVR 365/12.
Lordship, it's an old matter of
correct will
2012.
remain suspended.
Yes,
Deeply obliged.
suspended only till the next date,
Till
Lordship.
no till along till
Yes.
where will, huh?
Item number 14.
Roshana Begum.
May I please, Lordship. Lordship, in this case, the petitioner was born and brought up in the state of West Bengal, Lordship. Now, and she was shifted due to her marriage, and he was educed with documents, Lordship, since 1958, registered cell date. And
If you had married in West Bengal, there would have been no problem.
yes, Lord. Lordship, the first documents,
Where
Lordship,
did you get married?
Lordship, Lordship, in the year 2002, Lordship,
Where in Assam?
in the Assam,
Where?
Dhubri district, Lordship.
Dhubri. You
Yes.
came all the way from Bengal.
Lordship, adjacent district, that's why, Lordship.
Adjacent. Dhubri and the Bengal adjacent again.
Yes.
Little bit, there's
Huh?
a border
Border
in between.
border to Jalpaiguri,
No, Lordship, Coach Bihar. West
Coach
Bengal.
Bihar.
Yes.
And you are from where? Original from?
Coach Bihar, Lordship.
You are from Coach Bihar.
Yes.
But Coach Bihar also neighbor to Bangladesh.
Yes,
Yes,
Lordship.
Lordship,
So they suspected you have come from Bangladesh to Coach Bihar to
Neighbors
Dhubri.
look alike after a few years, it is like that now.
Lordship, here in this,
any document to say that you are Indian clause, any document.
Lordship, he was Lordship, first document is the 1958 cell deed, registered cell deed in the
Page,
name of
page.
page 21, Lordship, in her father's name.
21.
Yes, Lordship. MD Suleiman Ali Mia, Lordship. This
Suleiman Ali Mia
yes, Lordship.
of Somser Ali Mia by religion, occupied farmer village, Agrabari, Kotwali, district Coach Bihar, Indranath Burman, 1966.
Yes, Lordship.
And how do you say that this Suleiman Ali is your father?
Lordship, kindly see, Lordship, the school certificate, page 40, Lordship.
Page 40.
Yes, Lordship.
Rosana Begum.
Yes, Lordship.
Is still a class 8.
Yes, Lordship.
So could
Then-
be her. Then
Then school, Lordship, record was duly proved, Lordship.
How?
That is page 68, Lordship.
page
68, 68.
68.
Yes, Lordship.
68.
The counterpart of that certificate already proved.
My
Lordship.
name is Dharmendra Roy, Police Station, Kuch Bihar, assistant teacher. On being summoned by headmaster, I am obliged to depose. Recommendation letter with headmaster, I am service assistant. Is a transfer solution name of Rosana Begum. Whatever school, this was service by DD and headmaster, I know. I have also brought recent. Now what is this? Why you are not believing this? She has managed to bring assistants all from Kuch Bihar.
Yes.
Kuch Bihar to which
This Lordship, the Sharon over under Agomoni PS, Lordship.
Dhubri.
Dhubri, Lordship.
Lordship, the voters list of her father is not continuous, the projected father. This is what is reflected in page 85, Lordship.
Okay, we'll examine.
Examine this
Lordship, in
matter.
this case, Lordship, I have already adduced the DW2 is my elder brother, but that DW or duly closed, but in this impugned order, Lordship, nowhere in place, Lordship, it is discussed or discarded, Lordship.
Where is it? Where is it?
Lordship, page 76, Lordship.
Yes.
76
Rosana
order, Lordship. So, Lordship, my humble submissions, Lordship.
Where is it? DW2.
Lordship.
Where is the
DW2,
evidence of
Lordship,
DW?
59.
Where is the DW2? Where is the statement?
Lordship, 59, Lordship, page.
59.
Yes, Lordship. This is chief.
Rasidul Islam.
Yes, Lordship.
DW2.
Yes, Lordship. And 68 page, Lordship, duly goes examination.
Page 58.
68, Lordship.
68. No, 68 is Dharmendra Roy.
No. 66, only.
Huh?
66.
60?
66.
66. My name Rasidul, I submitted my voter list I card. Office of the Foreigners Tribunal, Dhubri. Yes, he was examined.
Yes, Lordship, he also examined.
Then there is no in the consideration there is no.
No, Lordship, there is not a single word has been given, Lordship. Neither discussed nor discarded, Lordship. That's why my humble submissions, Lordship. My humble.
It's just a whisper, Lordship.
Whisper
saying-
also?
Yes.
Where
there
is
is, paragraph 9, page 81, saying that heard the parties and peruse the written statement evidence on affidavit filed by the OP, along with the depositions as well as the exhibits adduced by OPS DW1 and DW2 placed in
Yes.
support of a claim.
Yes. The first will be written exhibit 1,
Yes.
PW2, then PW1, PW upon PW1, PW1. PW was discussed,
Look,
but
Lordship,
then PW2 has been discussed, no?
Lordship, PW, Lordship, that is the official witness, Lordship.
Okay.
I am
OPS DW1, DW2.
Yes, Lordship, just that word, Lordship, and nothing.
Oh, yes. Yes, Verma, see, if he is not, then we have to remand it for reconsideration.
Yeah. To discuss the deposition. of
Whatever, because they have to
DW2.
refresh, not only DW, then entire.
Yes.
See, Verma, you must have, during your school days, you must have also did painting, no? Yeah. See, in these colors, we are to be given. Earlier time, we used to have this camlin, no?
Camlin.
With those plastic thing, no? All
Plastic,
those different colors, chocolate type, small. Though these colors, left to themselves, they will retain their original color. But if you put
Mixed it.
blue to yellow, a different color comes.
Yellow and orange.
And if you and that yellow, if you put red, a different color comes.
Okay.
So what we are trying to say is that if you put DW2 along with other evidence,
Differences.
the entire complex may change. We are not saying it will. It is why. Therefore, they have to reconsider afresh. by taking into consideration DW2.
Yes.
Because
But
it
no
may change the
fresh-
context,
But
complexion.
no fresh documents,
That,
nothing,
he is
only
not
what is
asking.
on record.
He also not asking.
Yes, Lordship.
They are not asking.
Yes, Lordship.
Only reconsideration
Along
by
with the
considering DW2
DW.
also.
Though it is not much, but let it be reconsidered.
Whether it is much or not, let him do that. Let the tribunal do that. Nico. Or Mr.
I hope, Lordship.
I hope learned counsel for the petitioner, also learned counsel for the state. Considering the nature of this case, and on hearing of the parties and on perusal of the records, we are of the view that the petition can be disposed of at this stage without calling for the records or issuing any formal notice to the respondents. Basic, only the bare facts which will be necessary for disposal are referred to. Upon a reference being made to the petitioner by the Foreigners Tribunal number 9 Dhubri in FT case number 9/111/GKJ/2018, the learned tribunal passed an opinion declaring the petitioner to be a foreigner who entered India, Assam after 25/3/1971, after considering various evidences which are adduced. However, without appreciating and considering the evidence of one witness produced by the, examined by the proceeding, namely
Rashidul Islam, Lordship. Rashidul Islam,
Rashidul Islam, who the petitioner claims to be her brother,
elder brother.
elder brother.
They have three mothers now. Is it from the same mother, Lordship?
That tribunal will find out.
Yes, Lordship.
You have three mothers.
Yes, Lord, my one biological mother and then two is stepmothers, Lordship.
And how about father? Only one side. Okay. Under the circumstances, it has been submitted by learned counsel for the petitioner that since the evidence of her brother, elder brother, who is vital and highly relevant, was not considered by the tribunal, the opinion of the tribunal suffers is vitiated. According to it has been submitted, the matter may be remanded. Full stop. Ms. Verma also submits that as far as the law is concerned, the tribunal expected to refer to all the relevant materials, evidences on record, and if the tribunal does not consider any important or relevant material, perhaps there may be ground for interference. However, it has to be ascertained from the record as to whether the tribunal did or did not consider any such vital material. Accordingly, in view of the submission made, we have gone through the opinion. From the opinion, it appears that the petitioner had, apart from filing her written statement, and adducing evidence herself, also had examined her elder brother as DW2, which finds reference in para 9 of the opinion. Full stop. While the learned tribunal has elaborately discussed the implication of the various various evidences adduced, unfortunately, the learned tribunal, as submitted by the learned counsel for the petitioner, has not referred or considered the said evidence evidence in the form of the position of the DW2. Full stop. Next, it is now well settled that whenever a decision-making authority takes a decision, it is obligated to take into consideration all the relevant facts and materials. And if any relevant and material fact or material had not been taken into considered by the decision-making authority, such the said decision arrived at cannot be considered to be valid inanimate, it will be vitiated due to non-application on mine on an important material fact or evidence. Under the circumstances, we have the view that the learned tribunal, having not considered the evidence of the elder brother of not considered the evidence of the projected elder brother of the petitioner, would stand vitiated. In our opinion, the said evidence will be highly relevant and material inasmuch as the issue before the tribunal is to determine the citizenship of the petitioner based on which basis citizen of the petitioner relating to which the evidence of his close relative becomes highly relevant and material. Under the circumstances, without going into the other grounds raised, we are inclined to allow this petition by setting aside the impugned or opinion dated so-and-so, pardon as so-and-so. Full stop. It goes without saying that and according to the remand and matter to the learned tribunal for fresh reconsideration by taking into account the evidence of DW2 so-and-so. It goes without saying that appreciation of evidence of DW2 in the it goes without saying that the learned tribunal, while doing so, shall reappreciate the entire evidence and afresh, not only in respect of, but not only consider the evidence of DW2 inasmuch as the evidence of DW2 may change the color or color of the evidentiary value of other evidences which have been brought in record. That exercise, however, is to be undertaken by the tribunal. First, accordingly, we allow this petition by setting aside so-and-so. Matter is remanded. Petitioner will appear before the learned tribunal on
within a
period of 1 month from today.
They apply.
Supplementary list for motion item 18.
May please.
Maqbool. What is this,
But
Maqbool?
I'm challenging the second reference.
Second.
Already a impugn order have been passed, which have been pending, a writ petition is pending here. Now a second reference notices have been issued by the same foreigners tribunal to us.
Okay. So notice, you are challenging the notice.
Yes.
Let us see the notice.
To page 26.
Page 26. Here is Srimati, no, Muhammad Maqbool Hussain, son of late Kitab Ali. Let us see the earlier.
Page 19.
Page 19. 19 is Maqbool Hussain, son of Kitab Ali, resident of Bolidonga. Appears to be same person.
Yes.
Okay, hard Mr. Lana counsel for the petition. In this petition, the petitioner has challenged the proceeding initiated against him by the foreigners tribunal. What? Which one? 6 Tezpur foreigners tribunal. 6 Tezpur Sutia. By which under FT case 6 case number 636 or
636/18.
18, alleging on the ground that the petitioner had been already earlier proceeded in FT case number
Page 19. 19 FT case number 613/2017.
whereby he was declared to be a foreigner.
Foreigner, ex parte.
Foreigner by an ex parte order, which is a subject matter of challenge before this court
Yes.
in WPC number
3409/2021.
It has been submitted that there could not be in an event whether he was declared foreigner or not in the earlier proceeding, there cannot be a subsequent another proceeding in respect to the same person. We have examined the notice in which the noticee is one MD Maqbool Hussain, son of late Kitab Ali, resident of village Baliding, police station Shutia, district Bishwanath. In the earlier opinion rendered, the proceeding name is as follows, now page 11. There appears to be it appears that the present proceeding and the earlier proceeding appear to be same. Under the circumstances, we we direct that the subsequent proceeding initiated by the foreign traveler 6 days pool in FTC 360/20 shall remain suspended until further order.
But we maybe take with the.
This matter along with WPC number so and so, huh?
Deeply.
Daily list for admission, item number 15.
Porimol. Yes, sir. Porimol, what do you want?
My lord, in this case, my lord, NCR was called for, NCR received, my lord. My brother, my lord, my lord, sister, all are not declared as foreigner, my lord.
Foreigner?
No, my lord, I am only foreigner there.
You are the only foreigner.
Yes, my lord, because I was at Shillong, my lord.
Huh? You are
I
in
was
Shillong.
Shillong for 7-8 years, my lord. During
What?
that period, there was
Proceeding.
very big, yes, my lord. As
And
my-
you are the all your brothers, sisters declared Indian.
all Indian, man. All not declared, actually, they are all Indian.
They are
There
all
is no
Indian.
mark of D, man. They are all.
That means he has been marked D.
Only
He went to
petitioner is
Shillong.
from the year 11,
He was not in Assam, Porimol.
Procedural Rajvanshi. Otherwise, from 59 onwards, my lord, I have to have the, my lord, I have the total list of my
Okay,
grandparents.
what to do today?
May fix it up for hearing, lordship, since it's in the admission state, LCR is also there.
Since the records have been received, the matter will be listed for hearing. Otherwise, in the
Otherwise-
contested matter,
Protested, 3 witness examined my lord, my sister, my mother, and one of the
go on
relative
to
also.
some exhibit A, B on procedure file. Discussion. So the member has gone through, given reason order, so we'll examine. Okay. Since the records have been received, the matter will be listed for hearing. Yes.
For orders, item number 17.
Hari Mohan. What is this Hari Mohan Roy?
This is in fact a service matter.
Service matter?
Compulsory retirement. In fact, lordship along with Honorable Justice Maharashtra Nandi had heard it before. Then it went before another bench and it was directed to be listed before the appropriate bench.
What
Your
did we do?
lordship, you have-
CISF? Oh, that he
Yeah.
was speaking over the phone,
No,
something like that.
That matter.
That phone matter.
Yes, lordship.
Oh. See, you are determined to,
Lordship, I had apprised the authority, but I have been
authority
instructed.
that, yes, we don't
I have
want
been
him.
instructed to contest the matter. Lordship.
At least his name, at least in the name of his name. Hari Mohan. Hari. Every time you call out his name, at least you are uttering a very good name, huh?
Lordship.
Huh? What to do, Mr. Hari Mohan?
My lord, my there is my lord only one question, my lord. That my lord, this professionality, my lord.
This person, they say that Mr. Hari Mohan has been quarreling with his officer or something like that, huh?
That's
That-
that
And that, my lord,
that aspect of the matter, lordship, the single judge has not also gone into.
Has not gone into.
It's a trivial matter, but the first allegation, lordship, that he was using a mobile phone while on duty, that is the.
Mobile phone.
my lord, yes, my lord. That was wrong, my lord. That is not permissible. But my lord, under compelled situation, my lord. He had to carry on, my lord. And he was in mental agony also, my lord. And they could have considered, my lord. And nowadays, my lord, everybody carries me. Though although it is not permissible, my lord.
It was considered therefore compulsory retirement, otherwise it would have been a dismissal.
Compulsory retirement, you will get your pension now.
He will
With all benefits.
He will get a.
Then why do you want to work with them? I would be very happy if I get a pension. Go for pension. I want to take rest. Why you want to work so much? Night also. At least we are getting good environment. In your case, you have to go around in night time, all those things. Why you are given a golden opportunity, a golden handshake. You are not dismissed. If you have been dismissed, you will not get anything. Compulsory retirement means you go. Compulsory retire, you retirement. So what if your friend asks, what are you doing? Oh, now I have retired. You don't have to say compulsorily. I have retired now. You can join the retired club.
My lord, he was given compulsory retirement in the year 2015, my lord. And he was supposed to be retired in 2026, my lord. And
10
he was
years.
having a, my lord, 11 years service, my lord. That is why, my lord, he had.
But then they don't want you now. See, that is a problem, no? That page number? Page 86, no? Page?
83. Last paragraph.
Page 83.
Paragraph 86.
Page 83. See, in the present case, indicated has so and so, so and so, so and so. Page 26. Yes, Mr. What to do? Mr. Chaudhary knows. Hari name va kevalam. Kalo nasti. You don't know. Only Hari name is sufficient. Just chant it, you go to heaven, bliss. Then at least see they have given you, considering your name, they have given you compulsory retirement. Then at least you go back home, enjoy the pension. That's the one. This is otherwise. See, this is something which is bothering us also. Para 26. In the present case in hand, it is indicated by charge 3 that a petitioner awarded 2 major and 9 major penalties. Accordingly, 2 major were already awarded. What is this major penalty?
Lordship,
What is the major penalty? For what?
Lordship, I
Just see what is the major penalty?
Page 27, my lord.
Huh?
Page 27. my lord.
Page 27.
Lordship will see page 26.
Page 26.
Article of charge 3
No, but for what purpose?
is there, Lordship.
Withholding next increment for a period of 1 year without cumulative final order. Pay. Article 2 measure. Fine. See what kind of, see what did you? Reduction of pay. Absent. Reduction of pay. Unauthorizedly consume liquor in a civilian house and later got injured a scuffle with some civilians. You are fond of drinking also, no problem. Huh? Then you, after consuming this somras, you start fighting with. That's a problem. You just keep quiet, then no problem. Many people consume and quietly go to bed.
Minors are sleeping on duties, couple with colleagues, misbehave with seniors, creating nuisance, etc.
Misbehaving with seniors. That's why they are a little bit not keen to keep you. Because if you retain in service, number one, you may still drink and have another bout of scuffle with
My lord.
civilians and officials.
Here, my lord, kindly
Okay.
consider one aspect, my lord.
Yes.
This is the during the initial stage of his service career, my lord.
Initial stage. Oh,
my lord.
no, he has improved. That you have not.
Their last,
Yes, see,
for the, my lord, for the
you
last
can't
time
keep on racking up the past. He has improved. 1988, 1994,
for the last time, my lord,
95,
2004,
2000. What was the last time? 2004.
thereafter,
For
no-
creating nuisance, doing shift fall in nights. What kind of nuisance you created?
nothing, my lord. The mere shouting is also
Shouting nuisance.
nuisance, my lord.
Lordship,
My lord,
in fact, the
See,
antecedents are.
see, mister, then you have to bring a judgment.
my lord,
See, any punishment imposed, say 10, 20 years before, it loses the sting.
my lord, there is a judgment, my lord, state of Gujarat versus Umed Bhai, my lord.
What is it?
I had supplied a copy, my lord.
Is
There
it
is a
so?
reference, my lord.
Is it so? Let us see. Let us see that. See, the punishment of
My lord,
see,
once it is, there, my lord.
otherwise there won't be any reformation. See,
Lordship,
otherwise, see, otherwise, if you expect only sadhu and sant to be government employees,
no, Lordship, it's
you will not get, you will all kind of people, no, who have some fault. Human beings, frailty of human beings, no. If you have forgiven him, unless the charge is such a nature, and that also took place long time back.
Lordship will kindly consider.
My
Firstly,
lord-
it's a discipline force. Secondly,
Correct?
where the CISF are deployed, They are deployed not like ordinary police, they are deployed in some specific installations, industries. This particular instance was at the port trust
Correct, correct.
in the airport.
Mr. Roy Chaudhary,
It
have
carries
you
lot
done
of-
any, see, correct, correct. Suppose if you are a BSF for the border and where you are not supposed to talk, and then the charge maybe they are talking with some foreigners or extremists or some terrorists. And so it's a serious breach on the security. But he said, I was talking to his wife, some pregnant wife
Yes,
or
ma'am.
something, he was saying.
Yes.
So from the mobile number, you can find out whom he was talking. If he's talking to your wife, and if a person can't talk to your wife, then serious problem. If he's found talking with some unauthorized person, some other stranger, you can say, no, sorry, you are absolutely a threat to our security, go.
Lordship, it is not a case where if perhaps he would have informed his superiors earlier, he maybe would have been allowed to carry a phone. There was no such endeavor, Lordship. He simply carried a phone, and when he was caught, then he entered into a quarrel or a scuffle. Now, had it been an information given beforehand to the authority, things would have been otherwise.
My lord,
Otherwise, anybody will carry a mobile
my
phone.
lord,
Lordship.
in this aspect, I have something to say, my lord. My lord, petitioner's wife has a language problem. My lord. She also understands my SMS, my lord. That's Rajbangshi, post-Rajbangshi language, my lord. And whenever there is a provision, my lord, he can inform the, my lord, concerned Choki, my lord, police post. Thereafter, he will inform the person concerned, my lord, then he will come, my lord. There's a communication gap, and since, my lord, and another aspect, my lord, in the year 2012, my lord, petitioner also got promotion, my lord.
2012,
Yes, my lord.
where is it? Then see, if you're giving promotion, that means in spite of his scuffle, drinking wine,
This
consuming
promotion-
liquor with,
This promotion was prior to this
correct.
incident.
But then this promotion is after these incidents whom we are now relying to saying that who have been two major penalties,
Yes,
these
yes.
major penalties.
Lordship,
When you promoted, you knew this service. You see this fellow, he drinks with civilians and has scuffle. Rajbangshi Manu ekdam mot khaye. Then again, this fellow again makes jhagara with his superiors. You saw all this in the record. But I said, no, let him be promoted. Promoted means reward. Very good. Sabash. Sabasi. God, yes, you go higher. Now, that time, then you remembered again, which you have forgotten in doing promotion. At a time of this penalty, you remember, oh, he was getting this too. Can you remember that again, which you had forgotten doing while giving promotion to him? That is what we are asking also.
Lordship, there were 3 charges framed. I guess
Correct. No,
And
that is one
Lordship,
aspect.
that
That
is-
is one aspect. But then if you bring those past
Lordship,
punishments,
even if I do not bring in charge number 2 and charge number 3, charge number 1 is enough.
what is the charge number 1?
Yes, 24.
Highly prejudicial good orders, shift so at about 600 when shifting the check duty or talking with his mobile phone instruction directions and actions. So talking over phone now.
That is the charge number.
That is
That
charge
is
number 2.
precisely the allegation, Lordship.
What we say is that what is the judgment? You said you have,
My lord, I have referred, my lord.
what is the judgment?
2001 3 SCC 314, my lord. State of Gujarat versus Umed Bhai, M. Patel. Para number 11. Yeah, 11, para number 11.
Para number?
11, my lord.
Roman 7.
My lord. And my lord, honorable single judge, my lord, has emphasized on this, my lord. Tab number 3, my lord.
What we can, Mr. Okay, informally, of course, we have done. That is not part of the record. So what will is that we'll direct you to reconsider by not taking into account the past, because you have given promotion. And we'll ask you another reconsider it. We'll not say that do this, do that, or something like that.
No, sure.
But in the meantime, take a fresh decision. But from today, that is today is what day?
7th.
7th of
December.
December, till you take a fresh decision. Within a period, how long will it take roughly?
Worship will give me 45 days. 6 weeks time.
45 days.
6 weeks time.
Huh?
6 weeks time. Worship.
6 weeks. 45 days, 6 weeks. In terms of month, how many? How will it take?
1.5 months.
1.5 months. 1.5 months. You're very particular. Not 2 months. Take 2 months, because you have to processing.
Yes.
Because this has to go through, because normally in discipline process it will be routed through. They will
Yes.
see 2 months. In the meantime, we have time to go to Supreme Court also. You can go to Supreme Court. If you're not satisfied, then you can whatever. Then from 7th of December till you take a decision, he'll deem to be in suspension. But earlier period that we are not going, no work, no pay. So don't worry about that.
Lordship, just one thing is worrying me, Lordship. If he has drawn his pensionary benefits in between.
You have drawn.
No, man.
I do not know, Lordship.
Have you drawn? Enjoying?
No, man.
Because it's been
Till the
quite
last
a long
day, my lord,
time. How he's surviving, that is also good. It's been quite a long time, Lordship.
He can survive. See, human survival, he's a trained person.
Yes.
He knows how to survive. So
If my learned friend says that he has
you'll not
not
ask
done
too many questions to him, because it will amount to invasion of his privacy. So long as he's not doing any illegal work. Are you sure that you are not drawing your salary?
Till the last date, my lord, he was not doing, my lord. Now, at present, my lord, I don't have instruction, my lord.
You have the instruction, otherwise we can't pass his order.
My lord.
Because you have already enjoying salary. Then we cannot say that, you'll be deemed to be, so that may create problem.
My lord, my lord.
Lordship,
Because they will automatically, if there is no stay, then they will automatically transfer the pension to his bank.
Okay, 2 months you take a decision with, huh? Then we set aside, if you have to reconsider, you have to set aside.
Lordship.
Then what is that order you want then in that case? I'm not saying that we not quote you. What do you suggest? To be,
Lordship, if he can take his instructions by Friday, Lordship.
no, even if he has withdrawn some salary, obviously he has to feed himself, his wife, his children,
From the court.
because that can be always adjusted.
Just
Because that can be always adjusted.
can be
Because unless he has been given and released all the benefits, all those GVF, TPF,
Lordship. Those can be adjusted. Lordship.
that can be adjusted. Heard Mr.
Yes, okay.
As Hog Learned Counsel appearing for the appellant. How also Mr. R.K. Dev Chaudhary Learned Assistant Solicitor General of India appearing for the respondents. You are the one? Only? Yes, with assisted by Miss.
Lordship, she's not in the.
Not in
government
the.
panel.
Oh, you are a central.
Lordship, a small correction.
Okay.
DSGM.
Sorry.
Now the designation has been changed, Lordship. It's
Oh.
deputy,
It has been referred as a.
deputy solicitor.
Oh, I see. Deputy. Earlier it was correct.
No, it's all the same, Lordship.
Oh,
Because
same.
there was a confusion between additional and assistant.
But you are deputy.
Deputy.
But in police, assistant and deputy are different, no?
Yes, Lordship.
Deputy is
Now there
and
is no
assistant
assistant.
is, huh?
Now there is no assistant.
Oh, no assistant. All
No.
abolished, all deputy. Oh. Okay. I learned Deputy Solicitor General of India, appearing for the respondent. The present appeal has been filed by the appellant against the preferred by the appellant against the order dated 16/7/2019, passed by the learned single judge in WPC number 62 so and so, by which the learned single judge dismissed the challenge to the final order dated 23/5/2015, passed by the discipline authority, by which the penalty of compulsory retirement from service with pension was imposed with the benefit of pension and gratuity with immediate effect. Brief facts of the case as may be relevant for deciding this appeal may be stated as follows. The case of the appellant is that he was initially appointed as a constable of Central Industrial Security Service (CISF) in the year 1986. And thereafter he was promoted to the post of head constable in the year 2012. And he was still continuing that, and till he was compulsory retired from service. According to the appellant, while discharging his duty as the head constable in CIF unit in KOPT, Kolkata, he was detailed for duty
from 6:00 hours to
for a duty from
6
6
6
AM
hours
to
to
6 PM.
18 hours at a location at about 16:05 hours on 7/12/2014, when the B shift in charge /SI/EXE T Sudhakar was checking the said duty post. It was found that the appellant was talking on his mobile phone, with his mobile phone, and using the same during duty hours, which was strictly prohibited. Accordingly, the appellant was served with a memorandum dated 29/1/2015 with containing 3 articles of charges. The aforesaid 3 charges of article read as follows. Article 1, Article 3. Accordingly, a disciplinary proceeding was initiated against the appellant. In the proceeding, before the the appellant took the plea that at a relevant time he was talking with his wife, who was seriously ill and was undergoing treatment at the hospital at Chapor in Dhubri district, Assam. He also submitted that as his wife was undergoing treatment, he became anxious, and just to keep in touch with his ailing wife, he had carried the mobile phone, and it was not a case of deliberate misconduct contrary to the instruction issued in that regard. Next para. The appellant also took the plea that normally a person is assigned a shift duty of 6 hours, but on that particular day, on 7/12/2014, he was directed to remain on duty for 12 hours. 10 hours. 12. Double.
Double.
And as such, the petitioner carried his mobile phone to remain in touch with his wife. On conclusion of the discipline proceeding, the discipline authority held that all the 3 charges against the appellant has been proved, as he was found to be in possession of a mobile phone contrary to the instructions and was found talking with his mobile phone, talking with or talking over, talking on, no? Talking on, was found talking on his mobile phone in violation of the directions issued in that regard, and the disciplinary authority, by taking into consideration the earlier penalty imposed on the appellant, as mentioned in the article of charge 3, that he had been punished earlier 2 major and 9 major penalties, minor penalties on various occasions for his incorrigible habits during the service tenure, imposed the aforesaid penalty of compulsory retirement from service with full pension and gratuity with immediate effect. Being aggrieved, next para, being aggrieved by the aforesaid penalty of compulsory retirement from service, the appellant preferred an appeal before the appellate authority, making the same plea that he had used a mobile phone to talk to his ailing wife on the day of the incident, and as such, it was due to anxiety as his wife was undergoing treatment and who was away from his place of posting, treatment in Assam, and he was away from his posting in Kolkata. And accordingly, he pleaded that because of the aforesaid use of mobile phone, no untoward incident had happened during his duty period. He also pleaded that his wife cannot speak in Hindi and can only understand her mother tongue of
That is,
mother,
you may say, now Assamese.
now Assamese.
Because Kosa language is not yet recognized.
Oh.
Assamese.
Whether it is recognized or not, how does it matter? Your mother tongue is what?
Rajbangshi.
Rajbangshi. No, you spoke in Rajbangshi or Assamese?
Rajbangshi.
You say that. It's a part of Assamese, Rajbangshi.
Yeah.
But so your language is Rajbangshi. No?
Rajbangshi.
He spoke in mother tongue in Rajbangshi. In her mother tongue / dialect of Rajbangshi. And there was no, there could not have been occasion for his wife to communicate through any other person other than the appellant. First of next para. However, the appellate authority did not agree with the submission made by the appellant and affirmed the order of compulsory retirement from service with full pension gratuity by the impugned appellate order dated 5/8/2015. Goes from next para. Being agreed by the aforesaid order of penalty imposed by the disciplinary authority and upheld by the appellate authority, in rejecting his plea, the petitioner has approached this court by filing a writ petition, being WPC number 6282 of 2015, which was dismissed by the learned single judge by the impugned order dated 16/7/2019. Next, the learned single judge
16/7/2019.
2019. The learned single judge, after referring to the 3 articles of charges, 3 articles of charge frame referred to above, was of the view that the appellant petitioner was serving as a constable at the rebel time and as a member of a discipline force, he was not entitled to carry his mobile phone while on duty. And the article of charge 3 also clearly indicates the past misconducts for which he was put to notice by the authorities before the penalty was imposed. As regards the article of charge 3, the learned single judge took the view that the said article of charge 3 was not the article 3 was not a charge for which he was inflicted with punishment, but it was merely a reference to his past conduct.
Right.
Huh?
Fine. And not
For imposing the appropriate penalty
Ah.
in respect to other two charges under article of charge 1, 2. Next para. Coming to the article of charge 2, the learned single judge refrained from giving an opinion, as the learned single judge was the opinion that a charge against the appellant was not substantial enough to impose a penalty of removal by a compulsory term, and took the view that a substantial charge against the appellant relates to article charge 1. Number 2, learned single judge did not. Number 1, that is carrying a mobile phone and talking on a mobile phone while on duty. And as such, the learned single judge proceeded to examine as to whether the punishment imposed on the appellant was disproportionate to the nature of offence as contained in article charge 1. Next para. The learned single judge took the view that the appellant had admitted that he was using the mobile phone during the duty hours, and if the appellant's wife was having serious medical problem, the appellant could have informed this fact to the higher authorities and could have taken the consent from the superior officers to carry mobile phone, or ought to have sought permission to leave the post to speak to his wife, by the departmental phone. The learned single judge also was of opinion that since the appellant was aware that there was a prohibition of carrying, there was a prohibition on carrying a mobile phone during office hours, and since the said fact had been proved during the disciplinary proceeding, the punishment awarded to the appellant cannot be said to be disproportionate. However, the other issue raised by the respondent authorities as regards the lack of jurisdiction of the court were rejected by the learned single judge on the ground that once a writ petition had been admitted for hearing, it could not have been dismissed on the ground of alternative remedy. The learned single judge, while dismissing the writ petition, took note of the fact that appellant was earlier awarded 2 major and 9 minor penalties as mentioned in article of charge 3. In this appeal before us, Mr. Hogg, learned counsel for the appellant, has submitted that the authorities have committed a grave mistake in taking into consideration the earlier major and minor penalties as mentioned in article of charge 3 to impose the aforesaid punishment of compulsory retirement from service, which was also duly taken into consideration by the learned single judge. While dismissing the petition. Next paragraph. According to learned counsel for the appellant, if the aforesaid earlier penalties imposed on appellant are not taken into consideration, the compulsorily retiring a person because of use of mobile phone under the peculiar circumstances as referred to above would be disproportionate to the misconduct charged. Next paragraph. The learned counsel for the appellant also submits that the disciplinary authority could not have taken into consideration the earlier penalties imposed referred to in Article 3, to Article 3, as those were imposed long before and also before he was subsequently promoted to the higher post of
Head constable.
head constable
In the year 2012.
in the year 2012. And thus, the rendering the aforesaid penalties stale and no more relevant. It is, according to learned counsel for the appellant, it is on record that the last time the appellant was penalized was in the year 2004. And thereafter, because of his sincerity and dedication to duty, and as there was no adverse remarks, he was duly promoted to the post of head constable in the year 2012. According to learned counsel for the appellant, this factum of promotion to the higher post would clearly indicate that the earlier penalties imposed stand erased or wiped out for the purpose of consideration of his career service, as otherwise the appellant could not have been given promotion to a higher post of head constable. It has been submitted by learned counsel for the appellant that a promotion has been given if that the promotion has the effect of wiping out the earlier adverse service record has been also judicially taken notice. In this regard, learned counsel for the appellant has referred to the decision of the Honorable Supreme Court rendered in State of Gujarat versus Umed Bhai Patel, 2001, Volume 3, SCC 314, wherein it was held that if an officer is given promotion despite adverse entries made in the confidential record, that would be in fact that would be a fact in favor of the officer, as it would have effect of negating such adverse records for the purpose of career progression. Next one. There is another judgment perhaps you have referred.
Yes, madam.
That Pritam Singh or something.
Yes, yes, madam.
What is that? What is that? Pritam Singh. You had referred to some judgment also earlier. Pritam Singh, 2005.
2005 9 SCC 748.
Excellent.
2005 9 SCC
748.
madam.
What is that? Compulsory of judicial scope. Have judicial scope arbitrary.
And that is a not so relevant. madam.
Not so relevant. No, then why? Okay, not so relevant. Then any other judgment perhaps also in the note? There is also one Allahabad Bank Officers
Yes,
Association,
1990.
1996.
1996. 4 SCC.
4 SCC 504.
madam.
1996 4 SCC
504.
504. What is the para number which you are realized?
17.
Huh?
17. madam.
Let us see para 17. Wherein it has been held by the Honorable Supreme Court that learned counsel for the appellant also referred to the decision of the Honorable Supreme Court rendered in Allahabad Bank, so 1996, 4 SCC 504, wherein it has been held that if compulsory retirement amounts to casting a stigma it would not be permissible. There are also some Vaikuntha also you written from 1992. 1992, volume 2.
This judgment is covered by the earlier judgment.
Oh.
Compulsory retirement shall not be imposed
As a punishment. Yes. Okay. 1992, volume 2, SCC 299.
299.
We have an uncommunicated.
That was
advisory.
followed in the Umed Bhai case.
Okay, then anyway, these are all mentioned. According to yes, according to have been submitted by Lana Council for the appellant, that the fact that the petitioner appellant had used the mobile phone while on duty is not itself a grave, is not itself grave enough. It is not grave enough to justify the imposition of major penalty of compulsory retirement. Accordingly, it has been submitted that the disciplinary authority ought not have referred to the earlier penalties imposed on the appellant as mentioned in the article of charge 3 for the purpose of imposing the penalty of compulsory retirement, which is disproportionate to the charge. It has been also submitted that the use of mobile phone was under certain peculiar circumstances and also under compelling situation arising out of the medical treatment of his wife, who was staying in a far away location from his place of duty. And accordingly, it has been submitted that the impugned order of compulsory time may be set aside, and he submits that he is willing to accept any other penalty which is lesser than the aforesaid penalty and but proportionate to the charges proved. Mr. R.K. Dev Chaudhary, Lanet, DSGI, has submitted that in matters relating to disciplinary disciplined forces, and that too, when a punishment is imposed after going through the proper proceeding of his, there is no such irregularity. Penalty imposed by the disciplinary authority, which has been considered appropriate, normally cannot be interfered by the court in exercise of the jurisdiction under Article 220, unless it is found to be shockingly disproportionate to the charge. And it has been submitted that it is on record and also admitted by the appellant that he had used the mobile phone in spite of strict prohibition for the same. And being a member of the discipline force, he was fully aware of the consequences of disobeying the instruction of the higher authorities, that too while discharging an important duty of keeping up, remaining on guard, on sentry duty. Sentry duty, no?
Sensitive installations.
Of sensitive installations. Under the circumstances, it has been submitted that even if it may appear to be disproportionate from the point of view of the appellant, the disciplinary authority does not consider to be disproportionate. And in fact, it is a just punishment which has been imposed on him in light of this misconduct, proven misconduct. And it has been submitted that it does not call for any interference from this court. We have given our anxious consideration to the rival contentions as to what amounts a shockingly disproportionate punishment is sometimes a subjective, there is an element of subjective element while considering any plea raised by any delinquent that the punishment is disproportionate. Full stop. However, while considering any such plea, the attending circumstances has to be also looked into. And the incident which led to the punishment may not be looked in isolation, but in attending with the attending circumstances, and also the factors which led the disciplinary authority in passing such an order of passing order penalty. In the present case, while the appellant has strenuously tried to portray a picture before this court that his use of mobile phone was not a case of deliberate disobeying of instruction instruction not to carry mobile. On that particular age, he was assigned a long hours duty of 12 hours. 12 hours contrary to the normal hour of duty of 6 hours. And also, as his wife was undergoing treatment in his native place in Assam, which is far away from Kolkata, where the appellant was doing his duty. Mobile was the only means of expeditious communication to keep in touch with his ailing wife. And as such, it can be said that he was totally negligent of his duty by disregarding the instructions, though he admits that carrying a mobile phone is not allowed. However, what we have seen is that, however, keeping apart the aforesaid incident, what we have noted is that the discipline authority appeared to have been also influenced by the earlier penalties imposed on him, penalties of 2 major and minor, which also led to the imposition of the penalty of compulsory retirement. In this regard, we find force with the submission advanced by learned counsel for the appellant in the light of the decision of the Honorable Supreme Court rendered in state of in Umesh Bhai Patel Supra, that if an officer was given a promotion despite adverse entries made in a conference record, that is a fact in favor of the officer. It is on record that the officer was given promotion to the post, the appellant was given promotion to the post of
Head constable.
first constable in the year 2012. And all these adverse entries in his service record reflecting the imposition of 2 major and minor penalties relate to the period of, what is that? That was the period of
2004.
means that all those and that our
1988 to 2004, my lord.
led to the period of 2000.
Up to 14/6/2004.
Page
27.
Page 27. No?
Last is 14/6/2004.
14/6.
Relates to period of 1996
to 2002.
comma
No, that is
2000 comma 2001 comma 2002 comma 2 and 2004.
2002.
2002 and 2004. This is which is the last being on 2004.
First date is Lordship 1994.
1988, my lord.
The first being 1990.
1988 Lordship.
1988.
88.
It is okay. 1988. 1988. 89, 90, then 91, just happened. The last being on 2004, which is, and the penalty was imposed when? 2000, impugn order of compulsory order,
15
huh?
2015 May.
2015. Last being imposed on 2004, which is about 11 years, huh? 11 years before the order of compulsory retirement was imposed on him. As also mentioned by learned counsel, as mentioned by learned appellant, during this period, the petitioner was given promotion to a higher post of head constable in the year 2012. Thus, we have the view that the principle highlighted in Umesh Bhai Patel would come into play in as much as if the appellant had been promoted to the higher post of head constable in 2012, in spite of the existence of such adverse remarks relating to the period mentioned above, it will be deemed that the appointing authority did not consider such remarks to be of not to be impediment to the promotion of the appellant. Under the circumstances, if the competent authorities had not considered those remarks not to be sufficient to withhold his promotion to the higher post of head constable in 2012, we do not see any reason why these remarks could be used against him to impose the penalty of compulsory retirement. In our view, the aforesaid penalties by passage of time would lose their sting and accordingly can be considered to be stale and cannot be stale and stale and cannot be invoked, cannot be resurrected for the purpose of imposition of the penalty of compulsory retirement. To that extent, we are satisfied with the submission advanced by learned counsel for the appellant that the authority could not have taken these, disciplinary authority could not have taken into account these penalties. But as can be seen from the order of penalty and also from the observation made by the learned single judge, as contained in para number, learned single judge, para number 27 of the
26.
Page
26.
In para number 26 of the impugn of the order passed by the learned single judge on 16/7/2019, the aforesaid adverse entries did play a role in determining the quantum of punishment. Full stop. Next paragraph. Mr. R.K. Dev Chaudhary submits that even if these apparently past adverse entries be considered to be stale and not considered, the factum of his using mobile phone contrary to the instruction is sufficient enough to impose a penalty of compulsory retirement. However, we feel that is a matter that should be best left to be decided by the competent authority. Having found that the competent authority could not have taken into consideration the earlier adverse entries which we consider to be stale and cannot be used, having ignored by the authorities at a time of giving promotion to higher post of head constable in 2012. Certainly, these cannot be used in a subsequent period in 2015 when the order of penalty was imposed. Under the circumstances, we have to view that the authorities will require to revisit their decision as regards to whether to impose as regards the quantum of punishment to be imposed on him. For the above reason, we are satisfied that appellant has been able to make out a case for interference from this court. Accordingly, the appeal is allowed by interfering with the land as in the opinion of the landed decision of the landed single 16/7/2018, and consequently, we are also inclined to interfere with the order of penalty as well as the order of penalty dated by the disciplinary authority on
23/5/2015.
which was upheld by the appellate authority on
5/8/15.
consequently, the order of so and so are set aside, and the matter is remanded to the disciplinary authority for passing a fresh order of penalty without taking into consideration the past adverse remarks, as which is reflected in charge number 3. Under the circumstances, will accordingly, the petitioner shall be reinstated in service. However, he shall be deemed to be under suspension from today, from the day today, that is 7th of December 2022, till a fresh order of penalty is passed. As regards the earlier period, from the date of passing the date of compulsory retirement on
23/5/2015.
till today, since the petitioner has not rendered any service, even if that period also, even if the petitioner appellant will be also deemed to be under suspension, there shall be the question of payment of any allowance or salary for the period where he had not served will not arise. However, all this will be subject to the final order of penalty, which may be passed by the disciplinary authority. We are not asking for any payment of for that period, because he had not rendered, and therefore, and that was also subject.
Lordship will fix a time limit. Exercise.
But we expect that the authorities will pass a fresh order of punishment, preferably within a period from 2 months from today.
Lordship.
Order of punishment.
Yes, a fresh order of punishment.
He wants to be exonerated.
That no exoneration. So how can we do that?
I am not paying for that also, my lord.
Then
Just order of punishment, my lord, they will get some.
fresh order, fresh order as regards the proceeding initial, as regards the quad proceeding, disciplinary inquiry held against the petitioner without considering charge 3, without article of charge 3,
Right.
within a period of
Lordship.
not order of punishment, the appropriate order.
Consequential order.
Consequential order.
Right.
Quad discipline proceeding initiated against
Right.
him, with reference to charges, article of charge 1 and the 2.
Right.
Two already said. Charge number 1. In MHS, we also agree with the learned single judge view as we are also agree with the learned view of the learned single judge as regards charge number 2. But as far as charge number 3, for the reasons discussed above, we do not consider to be this cannot be acted upon, cannot be considered by the authority.
Right.
While taking a final decision.
Okay.
You will get this correction, I don't know, next week. Next week only, not today. And
For orders,
in the
item 9.
meantime, we can prepare SLP also. No problem.
Yes.
First Lordship, the judgment has to come.
I am grateful.
First, you have to get the certified copy. No, then we'll prepare the SLP.
For orders, item 19, supplementary list.
Item 19. This is item number 19. Rajendra Sharma.
Yes, ma'am.
What Rajendra Sama? Who are you?
I am the subject teacher.
You are a subject teacher.
I have, the question of seniority was under challenge. and,
Seniority, we
other-
cannot grant
Yes.
you. The law is against you.
Yes.
You cannot be given to get seniority, your appointment must be as per the vacancy must be there. And there must be, you must have been appointed as by adopting the regular process, except that Agharnath Day. Yes, Agharnath Day, mister. We have told you Agharnath Day, West Bengal. You are not brought it. You have to bring it then not today. Then we'll bring it ourselves. Agharnath Day. Just type out Agharnath Day in the search. Agharnath Day. Aghore perhaps. Agharnath. I don't know. Agharnath Day. I don't know if I'm correct. Agharnath Day. Agharnath Day. Yes. You have a very efficient court master. West Bengal was Agharnath Day. Yes, come down. Let us see. Come down, yes. Let us see. I forgot the para number. Can anybody help? Let us see. See maybe it will be found in the notes. Just a head note. Then just in conclusion will be para number 23. Okay, come to para 22. Come to para 22. Yes, come to para 22. Yes, just. Para 25. In our opinion, the conclusion B. You are relying on B?
Yes, madam.
See. In our opinion, the conclusion para B was added to cover a different kind of situation wherein the appointments were otherwise regular, except for the deficiency of certain procedural requirements laid down by rules. This is clear from the opening words of the conclusion B, namely, if the initial appointment is not made by following the procedure laid down by the rules and the letter expression till the regulation of service in accordance rule. We read conclusion B, and it must be so read to reconcile with conclusion A to cover the cases where the initial appointment is made against an existing vacancy, not limited to fixed period of time, or purpose where the appointment and is made subject to definition procedural requirement. Therefore, suppose a member is not present, procedure has to be followed. Perhaps that is not there. Otherwise, for all purpose, it is a regular. Then you will get a benefit of seniority. That is what Agharnath Day says. And you see, your appointment is you are hereby appointed as a subject in the business so and so, and your service will be treated honorary. You just went and made an application and you are appointed.
No.
Page 65. You are not subject to any screening.
No, it was.
This used to happen in 50s and 60s.
So far as 89th appointment, I am not.
About you want the benefit of the past service to be counted for the purpose of seniority, no?
Yeah.
You had applied, you made an application
But,
to the school, and the school said you come.
Yeah.
That's all.
Yeah.
That used to take place, correct? That was the procedure. I don't know about Assam, in Manipur also, in 60s, 50s, 60s. There were no graduates. So the secretary will say there is a post of this LD or at that time they used to be called clerks, no? LDA, no? Lower division, LDC, no? LDC, they said there is no application. Then they find out that somebody is walking on the street. I said, hey, how are you? They're not, have you done your graduation? Yes, I've done. Then come. There is a post vacant, nobody is applying. And he comes and he gets a job. I know many instances like that. Earlier times, see advertisement, see.
These are the things also happening.
Now, but then law is law.
Yeah.
You do not, number one, there was no advertisement.
Yeah.
There was no screening committee. So you just went, maybe you are known to, you may be knowing to, that maybe, who is this principal? What is the name of principal? Rongia?
Rogia High Secondary School.
What is his name? What is the name? I don't know what name is there. Is a painting is there. Some.
He applied on 25/7. Appointment was on 5/8. Name is not reflecting.
Anyway, one Mr. Principal, perhaps he knows you. I said, you come and apply.
No, my lord, actually, facts focus instruction I received. There are some other candidates before the committee, before a selection.
But why is that? You have to show there was a selection committee, there was advertisement.
You
Maybe others can might have, but then maybe the principal knows you better.
That may be,
And
but
then?
say 65, page 65 lordship.
And that's what we are saying in invitation reference, in reference to subject about your application dated 25/7, you are hereby appointed. You applied and you have appointed. No selection committee. It doesn't say that on the recommendation of a selection committee of the school.
Yes, thereafter, my lord, on when his post was regularized and he was, this appointment was now in question by the competent authority. And that was considered by the learned single judge also. And the competent authority also itself in opinion that no fresh regular appointment is required to be done.
Doesn't matter what, but then if you see that we can go beyond the law, let us see what you are saying.
On that point, law is some
Huh?
complex. Page number 53 may come out. Lordship. And page 53.
Just a minute. Huh? How many? लिखो. And Mr.
A. Paul.
A. Paulana, counsel for the appellant. In his appeal, the appellant is being aggrieved by the order passed by a single judge on 10/12/2015. The present appeal has been preferred. The case of the appellant is that he was initially appointed as a subject teacher in business organization and commercial practice in Rangia Higher Secondary School, White Order dated 5/8/1989. As per the order issued by the principal of the school, which was made on the proposal of the public general meeting held on 10/7/1989 and instructions given by the managing committee of the school. And accordingly, the petitioner joined, after being appointed in a said capacity, he joined the school on 10/8/1989. It is case that the Director of Secondary Education issued an order on 14/3/1996, wherein 3 different categories of posts were created in the Rongia Higher Secondary School, which were 1. Subject teacher of BOCP, number 2, Roman 2, subject teacher BNK, and number Roman 3, subject teacher BKA. And
For introducing additional streams.
for introducing additional streams in the school. And accordingly, as per order of the Director of Secondary Education Assam, White Order dated 27/3/1996, the petitioner was allotted the post of subject teacher of BOCP. Subsequently, on 13/11/2003, the Joint Director of Secondary Education Assam wrote a letter to the Inspector of Schools to the following effect. Page 68. Within quote, in inviting a reference to a subject cited above, I am directed to state that in the upgraded HS school in 1996, the subject teachers who were appointed by the managing committee of the school after due approval of the government along with the upgradation order, their appointments have been treated as regularly made. As such, no more regulation order is required in respect of these subject teachers. Please inform all the concerned. Next para. It is a plea of the petitioner appellant that because of this letter dated 13/11/2003 issued by the Joint Director of Secondary Education, the petitioner's service prior to this date of allotment of the post of subject teacher, White Order dated 26/3/1996, has to be counted for the purpose of seniority.
And also other
benefits. It was submitted that as the petitioner had initially joined the school as subject teacher POCP on 10/8/1989, the petitioner's seniority should be counted with effect from 10/8/1989. And as such, and in this regard, the petitioner had relied upon the judgment of the Honorable High Court, Honorable Supreme Court in Direct Recruit Case 1/2, Direct Recruit Class 2, Engineering Officers Association versus State of Maharashtra and others, reported 1992 SCC 715. Referring to the following paragraph, referring to the paragraph in the said judgment. B. If the you see page 69. If the initial appointment is not made by following the procedure laid down by the rules, but the appointee continues in the post uninterruptedly till the regulation of his service in accordance with the rules, the period of officiating service will be counted. Full stop. As regards the aforesaid plea taken by the petitioner, the stand of the state government was that the commerce stream of Rongia Higher Secondary School was provincialized only with effect from 14/3/1996, and as such, And thereafter, the petitioner appellant was made to hold the post only on 26/3/1996. And as such, there is no question of counting the petitioner's seniority as subject teacher, BOCP from 10/8/1989. It was also the stand of the state government that BOCP subject having been recognized in a school by the state respondent only on 14/3/1996. And as such, the service rendered by the petitioner appellant as subject teacher of BOCP prior to 14/3/1996 cannot be counted for the purpose of seniority. Next para. The learned single judge, after hearing the relevant contention of parties, made the following dismiss the petition by making following observation and conclusion. Para 8. Para 8. Indent 9. Full stop. Thus, from the above, it is clear, it is evident that the learned single judge held that para conclusion B of dire recruitment case supra referred to above is not applicable in the present applicable to the petitioner appellant. Full stop. We have heard the learned counsel for the also peruse the matter on record. We are also of the view that the learned observation finding by the learned single judge appears to be in accordance with the law. Full stop. Next paragraph. Though the petitioner appellant had relied on the conclusion B in dire recruit case referred to above, this conclusion B has been further explained by the Honorable Supreme Court in a subsequent decision in West Bengal, State of West Bengal and others versus Oghornath Day and others, 1993, 3 SCC 371. The Honorable Supreme Court, after the detailed discussion, consideration of the matter and the decision rendered in dire recruit case and other cases, concluded as follows. Para 25. In our opinion, para 25. Thus, from the above, it is clear that to get the benefit of service under conclusion B of the dire recruitment case 2, it is necessary that the initial appointment should have been made against an existing vacancy, at least against an existing, apart from the requirement that such appointment should not be limited to a fixed period of time or purpose, and was made subject to deficiency in the procedural requirements prescribed by the rules for adjudicating suitability of the appointee for the post being cured at a time of cured at a time of regularization, the appointee being eligible and qualified in every manner for a regular appointment on the date of initial appointment in such cases. Thus, one of the conditions required was that there should be a regular existing vacancy. In the present case, it is clearly seen from the record that the post was created only in the year the post was only on 14/3/1996 upon provincialization of the said school. The post the petitioner appellant was holding was prior to provincialization. The post and the period relating to which the petitioner appellant is claiming benefits relates to a period prior to provincialization. And it is well settled that even if there was a post in the school prior to provincialization, that post in any way cannot be equated with the post after provincialization. In as much as the character, nature of post pre-provincialization and post-provincial are of different nature. A regular post contemplated under rules will be those posts which would be existing only after provincialization. In other words, only after provincialization that a post becomes a regular government post to which a person may be entitled to the benefits attached to the same. Since no such government post was available before 14/3/1996, as the school was not yet provincialized, we have the view that the conclusion B mentioned in direct recruitment also will not be applicable, as has been rightly held by the learned single judge. Accordingly, for the reasons discussed above, we are not inclined, we do not find any merit in this appeal, and accordingly, the same sense dismissed.
Not the school, but the commerce stream, my lord.
And in the school, sorry, and the provincial in the commerce stream in the parliament.
My lord, one thing that seniority may not be considered, but his past services also have been considered and other pensionary benefit. Your lordship.
See. Mr. Paul also submits that even if seniority is not considered, other benefits can be given. As far as other benefits also are concerned, it goes without saying that such benefits must be with reference to the post he was holding. And if the post he was holding came into existence only on 14/3/1996, we are afraid we cannot give any such benefit also. In as much as he is not entitled to any benefits attached to the post which was not in existence prior to 14/3/1996. And for the reasons that we do not find.
But one funding is required in this case, my lord. Whatever service benefits ought to be, as per your lordship's view, have to be commenced with effect from 14/3/96, because so far as instruction, he has not entered.
Okay. Accordingly, it goes without saying that if the petitioner has not been given any benefit after 14/3/1996, when the post was created in the said provincialized school in the commerce stream, the petitioner shall be entitled to all such benefits attached to the said post from the date of his joining on
26/3/1996.
26 March
26 March
96.
97.
96.
And if not afforded to the petitioner, may be afforded without any as expedition as possible.
As he is retired at this moment.
Oh, he is retired.
Yes.
Retired.
Yes.
If possible, preferably within a period of 2 months from the date of registration. Qualification arbiter Bhuvanesh Prakash Khare. Presiding assumptions Bhuvanesh Prakash Khare and Rai. There is no agreement party from the train party. Huh? Yes, madam.
Lordship, Bijay Sharma, the
Ahana hai. To ki korbe
he has not come today.
Huh?
He has not come today.
He has not come today.
Yes.
The court to ছুটি নাই. We have not. Our winter vacation শুরু হয়ে গেল নাকি? নাই না? কোর্ট তো আছে চলি আছে। হ্যাঁ?
Sir, time will be given, sir.
Time may be given.
Yes.
কিমান time দিব? ক'ত দিব? Where?
After vacation, Lordship.
After vacation.
Sir,
And he will come after vacation. So vacation শুরু হয়ে গেল নাকি? হ্যাঁ?
Sorry.
কি? 2019 madam Shodha.
After vacation, you lodge.
After vacation. This vacation fever has started on again. Mr. Nair, vacation fever has started. They will say after vacation.
It's getting a bit cooler nowadays. Getting a bit cooler.
Hare Baba, this 2019 matter. The Supreme Court is watching. He said, what these judges are doing nothing. Adjourning Tariq pe Tariq day ja rahe. These lawyers are coming here. Judges are very good. Judges and lawyers are having a fine day. Nice time in Guwahati High Court. Lawyers are coming for time. Judges also giving very happily, smilingly giving time.
For any other date, you lodge.
For any other date. Come prepared, Sodha. Next week.
Next week.
Or Miss Sodha. Come prepared.
You lodge.
And next week date দিব
12, 12, 12, 14.
14. And please tell your
Yes,
he has not booked any ticket no outside.
no.
Who will appear?
Bijay Sharma.
Huh?
Bijay Sharma.
Vijay Sharma.
Yes, Lordship.
So tell Mr. Vijay Sharma also, we'll see what is to be done 2019 matter. Yes.
For admission, item 1.
Item number 1, Ganga.
Yes, Lordship.
Where is Ganga?
I'm for the respondent, Lordship.
You are from
Respondent.
railways.
Yes, Lordship.
And but where is from Ganga? Anybody from Ganga? No, 21. Hussein, so he would like to file reply. Huh? Earlier, Mr. R. Hussein
Yes.
submits that he would like to file reply to the additional affidavit filed by railways.
And
Has he
reply-
filed?
Reply is also filed.
He has filed.
Yes.
After filing reply, where is he gone? What is this? Do you have any idea, madam? Is it about the central, that one, or will refer what?
Some
Wow.
issues is there.
What kind of issue?
Two objection is also there. So one is the invoking the notice to the respondents within 180 days, but petitioners file the notice is after 2 years, Lordship.
After
So
2 years,
that is
delay,
the objection is.
delay. Delay, issue of delay is there.
And excess another is that more than 20% is the claim value of CA.
Okay. Okay. As known appears, though Ms.
Yes, Chakravarti.
S. Chakravarti, learned standing counsel railways appears, known appears for the petitioner. Accordingly, the matter stand adjourned to Tarikh Guru Eta.
1912.
Next.
1912.
Supplementary list for hearing item 3.
Sukhomoy de.
My lord, may it please your lordship. Lordship, the other day, lordship was pleased to ask for the comments of my lord, the finance department, my lord, as to how this 19,070 was calculated.
Yes, Mr. Bor Pujari. He said you have wrongly calculated. Is it right? No.
My lord, that statement is precisely to be traversed, my lord, by the registry of this honorable court.
No, registry is relying on you. Registry, you have given, the registry has complied with you have worked out, you have calculated that
1907.
1907. He says not 1907, I am entitled to 27 990. How do you have calculated to 1907?
Yes, that my lord will find in the affidavit, my lord, filed by the finance department.
Yes.
My lord, that affidavit, my lord, deponent is Aurobindo Burman.
Just a minute. Huh?
Well.
Just.
My lord, respondent number 5. Prior to his engagement, my lord, the petitioner was working in my lord, another establishment.
No, that filed by.
Filed by my lord, the respondent number 5, deponent is my lord Aurobindo Burman.
Aurobindo Burman, huh? And in that, there are page number?
There, my lord, will kindly come to page 4, paragraph 6.
Paragraph 6, okay.
Paragraph 6.
Yes, worked out, Mr. Nair.
My lord.
Okay, let us read again.
Yeah.
In this connection, the calculation of pay of the petitioner has been below. Pay on 9/1/19/2009, excluding grade pay 12,666 is correct?
No, my lord.
Huh?
No, my lord.
Then what is your?
It is to be 11,825, my lord.
No, pay is on 9/1/2009.
My lord. My lord.
Let us see my calculation yesterday. Your calculation.
My
What is
lord.
that? Page,
This is 11.
page number?
My lord.
Ah.
This is the initial pay statement.
No,
page-
yes, no, you have also calculated, no?
Yes, my lord.
What is it? What is it?
My lord, here page 52, my lord.
Page 52 of your petition, na?
Yes, my lord.
Page 52. Page 52.
My lord.
In pursuance of the ministry, or under memo so it will be revised The pay of Sukumoiro Day is ever fixed 2012. CBI, this is before you join, huh?
Yes.
Before you join,
Yes, that is before I joined, my lord, page 52, my lord.
page 52.
52, my lord.
Page 52. Existing scale of pay is,
57,252, 11,825,
so you are getting 11,
11,825, my lord.
11,825.
My lord.
They have given you higher, 12,600.
My lord, how this 12,660 came, it's not clear from here.
Existing pay of scale is 272,11825.
My,
Now add 3% increment on, if you add 3% on 11825, how much it comes?
my lord, this calculation is there in the ROP rules itself, my lord. As per fitment table 28, no, as per fitment table 22. My lord. Downward.
Yes, ROP, yes.
Fitment table 22, 2010. I have it ready with me, my lord.
Here also there.
Appendix 7.
1125.
My lord.
From where is add 3 increment for benefit of promotion appointment? What is this increment? Why?
May it please, your lordship. Lordship, will start with the last page certificate,
Yes,
page 46, my lord.
yes, yes.
The pay was 12,660 base, and grade pay was 4,200. And the last pay of the petitioner, it comes to 16,860. And it has been decided in the registry of this honorable court as well as by the in the government that this 16,860 has to be protected. There is no second opinion or second thought about it.
Yeah.
Then my lord will kindly come page 48.
Yes.
May I read, my lord?
Yeah.
This is regarding the fixation of basic pay in respect of Sri so-and-so who joined this registry as steno grade 1 through proper channel on 9109. Sri so-and-so was holding senior clerk steno in the Office of Central Bureau of Investigation, ACB, Guwahati, before joining this registry, and he was drawing his basic pay rupees 12,660 plus grade pay 4,200, total of which comes to 16,860 in the scale of pay rupees 9,300, 34,800 plus grade pay 4,200 as per his LPC and statement of fixation of initial basic pay at flag X and Y. But maximum scale of pay in the post of steno grade 1 now he has joined is 11,825. In the pay scale of 5,725, 11,825. Pay scale is 5,725, 11,825.
Correct.
Hence, he is drawing much more basic pay than maximum scale of pay of steno grade 1, that is 11,825 of this registry. In such a position, he may perhaps be allowed to draw last scale of rupees 11,825. And this is important. In the meantime, the government of Assam may be moved for fixation of his pay. Or she will kindly mark this. An argument was made by the petitioner that it was decided by the Chief Justice, then by the this Honorable Registry, and it was final. And there was no tentativeness in the decision. So from here, when this office note was issued, immediately on 4/2/2009, it was decided that in the meantime, the government of Assam may be moved for fixation of his basic pay. That means his fixation was not final at that point of time.
Very well.
Now down below, my lord, Sri so-and-so is appointed as steno grade 1 in the scale of pay of rupees so-and-so from the SB of Sri.
SB means what?
Service book.
Service book, my lord.
Okay.
SB of Sri So, it is seen that his basic pay plus grade pay is 16,860 as on 1/7/2009.
9.
It has to be 2009, my lord.
9.
Just. Eraser. Where is my eraser? Eraser lage, pencil lele, eraser dibo lagi boy. No, there is no law. If you give pencil, you must give eraser also. There is a law which we learned during the school. Huh? No.
Yes, ma'am.
2009 is the max service book. So this we have derived from service book.
Yes.
As the maximum basic pay of post is 1 month, the basic pay of may not be allowed to it is higher
As
than
the
the 1 month.
maximum of the basic pay of the post of stenographer grade
Yes.
1 is rupees so-and-so. The basic pay of Sri Day may not be allowed at a stage higher than that of 11,825 under the
Very
rules.
good.
So
Yes.
that was the decision.
Yes.
Also will kindly appreciate till that time, the ROP rule 2010 was not implemented in the
Correct.
High Court.
Yes.
This was interim arrangement.
Yes, yes.
Now, my lord will kindly come to the page 52.
Page 52.
That the fixation done, which as per the petitioner is correct, and which was later on corrected by the government as well as the registry. Lordship will kindly see existing scale of pay. Lordship will note down 5725, 11,825. Basic pay revised as because it was decided he will be given the highest of the pay band.
Correct.
So 11,825 was given.
Yes.
Then by using the comparative, my lord, the fitment table of
Yes.
the ROP rule 2010 that my lord, my friend has shown on the
It's
last day.
given 2790.
11,825
Yes.
as per fitment table 22, it comes to 22,000. And grade pay was given 5,900. And in total, it comes 27,900.
Correct.
That was the fixation done at that point of time.
Yes. Then
This was basically pay revision. His
yes.
pay was revised.
Yes. that is as on 24/3.
Yes.
Is on 24/3/2010.
24/3/2010 was the date of this fixation, my lord.
So 2790. Then, yeah.
Then my lord will kindly come. Thereafter, Lord, he has got this order, page 60 was issued.
Page 60.
Yes, my lord.
What is that order?
Page 60, annexure 11.
Appointment.
So and so appointed by notification dated so and so. Plus he was regularized, my lord, by this order.
Regularized material.
Yes.
No.
Now a complaint that was filed.
Doesn't matter then whatever it is.
So
then
I'm just reading a paragraph of the complaint, my lord. It's it was not given credence by the registry also.
Don't read the complaint. Let us see complaint to everybody writes so many complaints.
Fine.
There's so many complaints against me also.
Yes.
If you ask the Chief Justice office and ask what are complaints, Justice Kote so there.
Absolutely correct.
So forget about
We
this
are
one.
prone to complain. My lord, then come
And
to
we are
page
good
7.
writing also. We are good petition writers. Then come to the next.
Page 70, my lord.
Page 70.
Yes.
Yes, page 70.
This was the, my lord, approved by the Honorable Chief Justice, my lord.
Yes.
This is regarding an anonymous representation dated so and so in respect.
Anyway, this we have gone through. So this note does not actually fix what is.
No.
Actually
Till
doesn't fix.
date, it is tentative.
Yeah,
I'll just read
this note is simply he was getting so and so. So and he's perhaps is entitled to pay protection.
No, it says down below, it may be mentioned that while fixing the pay of Sri Day,
correct,
suggestions has been given to the effect that the government of Assam may be moved
correct
for
Okay.
fixation of his pay.
No problem.
But this has not been done. In that view of the matter, if it pleases your lordships, the matter may perhaps be referred to the government for approval.
See, two
That means
things.
still that,
Correct, correct. See, two things as I can read.
my lord.
When this is it for approval, approval means what? To move the government for fixation of pay. Please
Yes.
approve this process. Or he saying approve means this one. Doesn't matter. In any event, it has to be fixed by the state government.
Contention of the petitioner is that
Assuming-
High Court
correct.
has fixed the pay.
Correct.
and
Assume,
sent for approval, government cannot do anything.
no,
It
no,
has to
let us
accept it
assume the
and-
government also can do.
So
Understand?
my contention is that, my lord, till that time, everything was tentative. Initially,
very well.
immediately also, it was placed.
Okay, we accept
Yes.
your view,
My
then
lord.
what the government has
I am
done.
obliged, my lord.
If that is so, then what the government has
Then
done.
page 71, my lord, there is another noting, my lord, as approved, the matter regarding fixation of so-and-so referred to Finance Department, Government also for approval, as proposed above, account section take up the matter of fixation. Then, my lord, will kindly come to page 74. This was a communication issued by Deputy Registrar Finance Guwahati High Court to the LR, joint
Yes.
LR, my lord. I propose the subject cited above. I am directed to inform you that so and so had joined this registry as stenographer so and so. Prior to joining this registry, so and so was working as senior clerk cum stenographer CBI Guwahati in the office of Superintendent CBI ACB Guwahati and drawing basic pay of rupees 16,860.
Acha, we have gone through this. What is the double benefit? What is this? From where this concept called double benefit came?
It's a double benefit in
No,
other,
no,
in
no.
other sense.
Why
What?
is it double benefit in the same organization? One thing. Double benefit, when you said double benefit, you can have double benefit in the same organization. But what is this concept of double benefit? Is there any law? Or is it conjured by some very brilliant imaginative officer? What is this
In
double
fact,
benefit?
In fact, Milord,
Who has coined this word double benefit?
in fact, even if we do not go into this aspect of the matter also,
So the government has to fix in any event whether the High Court says double benefit, triple benefit, quadruple benefit,
Right.
government has to fix.
yes,
What is the law? The government has to fix on certain norm,
yes,
certain formula,
yes,
certain criteria,
correct,
certain principle.
correct,
Show us that principle.
yes. So
That's
the
we are
decision of
concerned
the-
with.
Decision of the government came, Milord, this by this page 78.
That the page 78, we have seen that it doesn't mean anything to us. That is
Yes,
what
it
is being
means a
challenged.
lot, Milord. I'm
Yes,
just
tell us.
listening.
Yes.
Finance Department observed the last pay of so-and-so.
Yes.
Drawn
And
in
then
former
from
post
so
under
and so,
six
maybe
pay
protect
commission
fix
will be
so and so.
fixed at
On
the stage
appointment
of so-and-so. Now
Then-
this 19070, how it came, that is the crux of the issue, my lord.
And
the
maybe
scale
protected fees at the stage of pay of rupees 190. From where? it got this?
19070 in the
Oh, why
scale
got
of
this?
rupees so-and-so with grade pay of so-and-so under 6 pay commission government appointment joining as stenographer, Guwahati High Court with effect on date of next
Okay.
increment as
Ah.
per provision of rule 11 and read with FR 22 1A1.
So tell us this, how we are
Now,
able to.
My lord will kindly have my list of dates that day I have given, my lord.
List of dates.
Yes.
I see. List of date. Yes, I got it.
Lots.
Yes.
My lord. No, Beleg Bushfi.
Yes.
Lordships, page 4, my lord will kindly have a look.
Page 4, yes.
So on 28/6/1990, his pay scale was 1200 to 2040
Hmm.
in CBI.
Yes.
On June 2002, he was granted ACB benefit 5,500, 9,000.
Yes.
This pay scale was given to him by virtue of ACP benefit. Now the central government implemented the ROP rule 2008 with effect from 1/1/2006.
Okay.
Now, Lordship, his pre-revised pay scale before implementation of ROP rule 2008 in CBI was 5,500 to 9,000. Lordship will kindly mark this. So it was revised to 9,300, 34,800 with grade pay of 4,200. Revised with effect from 1/1/2006. So one benefit of revision, the is already there in CBI. Now on 9/1/2009, he joined the High Court as steno grade 1 in the pay scale of 5725-11825. Now this 11,825 is the pre-revised pay scale. This is as per fifth CPC
Of the High Court. Yes.
of the High Court, because till that time the 6th CPC was not implemented.
Correct.
That means he traveled from the pay scale of 5,500, 9,000.
Which is a revised.
No, pre-revised
Pre-revised
in CBI.
in CBI.
Look, why he came to High Court? Obviously for some benefit. Obviously his pay will be enhanced. That's why he has come.
Correct.
So
When-
he came from 5,500, 9,000 was his pay in the CBI.
Correct.
4th CPC.
Yes.
Sorry, 5th CPC.
Yes.
Then he traveled to 5725, 11,825, 5th CPC. No.
No.
I'll come to
See.
Lordship's query, my lord.
Correct. See, when he was given this ACP, he was in CBI.
CBI.
And when this 6th pay commission was implemented, was he in CBI or not?
CBI.
And then if
So-
he does not join the High Court, he would be entitled to the revise as per the revision as per the 6th pay.
I'm just coming to that, my lord. My lord, I'm just explaining your lordships, these two pay scale, that is
Yes.
5,500, 9,000 and 5,725, 11,825,
No,
only to demonstrate that these were the pre-revised pay scale.
pre-pay in the High Court. In the High Court.
One is in CBI,
Forget
one
the
is in High
CBI.
Court.
So why?
So in between,
Yes, yes,
one is in High Court.
yes.
Now, he joined on 19/1/2019
Yes.
in the High Court. So his last pay certificate issued, it was his last pay was shown as 16,860.
Correct.
This is after 6 CPC implementation.
Correct.
So what we are required to do is that to protect this pay scale.
Correct.
There is no disagreement to that effect,
Yes, yes.
either by the High Court
Correct,
or
correct.
by the state.
Correct.
Now,
So in order to protect, he was given 11,825,
yes.
isn't it?
No, Milord. 11,825 was a Milord in.
So
is a-
you want to
was
say
a
that this
stopgap arrangement.
last pay certificate 16,860 has to be protected.
Milord, assuming-
Therefore, the
Yes.
last pay has to be protected. Yes, I have come then and
Yes.
Assam pay was 2006. Let us see. Yes,
Yes.
it has to be protected. In
Last-
one man,
Our duty was to
protect his,
18, Milord, 16,860.
correct?
Now, whatever has happened in the meantime before coming of the Milord, before implementation of the ROP rule 2010 in Assam, those were all stopgap arrangements, Milord.
Correct.
Those were because pending finalization implementation.
Correct.
At that point of time, office note was put up
Yes.
that since he was getting the getting a pay
Yes.
more than the highest of the pay band, Milord. So
Yes.
he has to be given the highest. That was the decision taken at that point of time.
Yes.
But as per law, we are to protect his 16,860.
Correct.
Now, my lord will kindly have a look. My lord, I have given a bunch of paper. There is a circular of central government, my lord.
Yes.
Now, how pay protection is to be given?
That what you tell us. That you tell us how the mechanism. He's as per him, as per the petitioner, the mechanism is simple. He should be given
That mechanism
600,
shown.
860, but since it is not the pay scale, is beyond that, at least he will be given the last maximum. That's what he is working on that mechanism.
That mechanism, my lord, is
Yes, yes.
correct.
Correct. Then you show us the correct mechanism.
Parsada. My lord will kindly have a look.
But then another thing, okay, you say that the new post, as per new post, pay protection will be 19,070.
Yes.
Okay.
So
Is
I
he- so is he entitled to revision to that?
Sorry, Miller.
Is he entitled to revision to that?
Miller, there is no question of revision because his
No,
pay
no, no,
was
you
already-
apply, you apply. He has to be given the pay scale as per, forget about his post, huh? All are getting who are working in the government, in the Guwahati High Court, they are getting the revised pay under the, what is it, Rule 10?
ROP Rule 2010.
10, huh?
Yes.
Is that benefit also given to him?
No, Lordship will
Is he
kind-
given to him? Is he entitled
It
to that benefit also?
automatically comes.
Huh?
Once his fixation is made in terms of this office
So
memorandum.
if his fix is 19, so you give the revise as per the revision then?
Lordship will kindly have a look this Milord circular of the DOPT.
Okay,
It says how Milord it is to be
okay,
fixed.
okay.
Fixation of pay of state government employees on their appointment in central government subsequent to implementation of.
No, on their appointment, let us
No,
forget this.
this has got relevance, Milord. Lordship will bear with me.
No, why you bear? Because see, fixed was from the state government to central government. How it is applicable? Why are confusing this code? You give a principle. No, you are reading an office memorandum which is meant for those state government employees who get appointed in central government. Then why you are confusing this? Don't bring this, which is not at all applicable. Are you frame a rule, office memorandum?
All right, Lordship will then.
Sorry, then I
Lordship
will not look into it because you will confuse me. Because this OM is meant for those revision of pay of those state government.
Milord.
If a state government employee, he wants to join the CBI, then in that case, this will be applicable. This principle, whatever is there.
Milord, why I have
No,
placed
but
this-
because that you cannot say that the vice versa also applicable.
Milord, I'll place, Milord, for your Lordship's understanding, Milord.
No,
I have placed this.
No, I will.
I'll place the Milord.
This I will not look into it because it will
Lordship
confuse.
will look into it after going by the Milord.
Unless
considering
the
the
government has
information.
said, unless the government has same principle which is contained OM dated 28 August 2014
Fine,
also will be applied in respect of those central government employees who come to state government.
My lord will look into this office memorandum after a little after.
Okay, well,
after some time.
not now I will look. Once you
Lordship-
convince
Lordship
I can look, I will look.
Lordship
Yes.
will kindly see.
I will keep, yes.
Lordship will kindly have a look at the FRSR, my lord.
Yes, FRSR. Dio FRSR. Yes,
FR 22-1A1.
FR 22.
1 numerical 1 A and Roman 1.
22-1.
Este বেলে গইবা নতুন কিতাব
নতুন মোরে
22.
1 A1.
For A1. There is nothing like
এখানে-
1A1.
আসলে এখন দিবা।
My lord, it is 22A, that one is missing in the print, my lord.
No.
After FR 22, that one is missing.
That is not.
Just see, I don't know who is publishing this Orient Publishing Company. Don't buy. They are confusing. We are already confused. Then they are confusing us more.
একেখনে
ইয়াতে মই উলাই দি আছো ৰব। 21 or 80.
Yes,
My lord, will have that FR 22-1 in the top left-hand side, I think.
just a minute. What is this?
Huh?
Time scale of pay 21. Rule 22 to 22
Yes,
may
in
apply to
first,
time scales of pay generally. They do not, however, apply to any time scale sanctioned by the state government insofar they are inconsistent with the terms specifically so sanctioned for such times. And 20, the initial pay of a government servant who is appointed to a post on a time scale of pay is regulated as follows. And then what do you want? Yes,
yes,
please.
may I read, my lord?
Yes,
A1,
yes.
where a government servant holding a post other than a tenure post in a substantive or temporary or officiating capacity is promoted or appointed in a substantive, temporary, or officiating capacity, as the case may be, subject to the fulfillment of the eligibility conditions as prescribed in the relevant recruitment rules, to another post carrying duties and responsibilities of greater importance than those attaching to the post held by him, his initial pay in the time scale of the higher post shall be fixed at the stage next above the notional pay arrived at by increasing his pay in respect of the lower post held by him regularly by an increment. This is important, Milord. By an increment at the stage at which such pay has accrued. Lordship will kindly stop here. Milord, this FR 22A 1A1 has been referred by the Finance Department also in their communication to the Guwahati High Court. It has been referred in the impugn order also. In the affidavit also, the Finance Department has referred this rule. So what happens in this matter, Milord? How this is, Milord, implemented? A person, when he is appointed, this rule says, either promoted or appointed, he will be entitled to one increment in the notional pay. So if my lord will kindly take up my list of dates that I have given the calculation, that 3% your lordship was asking day before yesterday, where from this 3% comes? This 3% is the increment, my lord, because as per ROP rule 2010, the increment determined was 3%. I'll take your lordships to the ROP, my lord. Now, how this calculation was made and how 19070 comes. Last pay as per the ROP to be protected was 16860. That is 12,660 plus 4,200. 3% of 16860 has to be taken. And this aspect has been further clarified in the central government circular that I have given. That's why I made a mistake by referring to that earlier, Milord. Lordship will be more clarified about this by looking into that circular.
So we add this 3% increment.
Yes, we add this 3% increment to 16860. So it comes to 505.8. Then protected pay would be 12,660. That's the basic one. And 505.
What about the grade pay?
Grade pay will come. He will get the new grade pay. His benefit, what benefit he will get?
So this increment also he'll get plus grade pay.
Yes.
Therefore, the new post after pay protection is 19070. Very good.
What
then
he'll get, first of all, because of his pay protection, firstly, he is coming from a lower scale to higher scale when he came to High Court. And when the benefit he will get is that one increment and the higher grade pay. After revision, he will get this 5900 grade pay.
Correct.
His that 11875 will not be revised as per the ROP rule 2010 by comparing the fitment table. This is wrong. It has not been provided in the rules. Now, Lordship will kindly see the 2014 circular of the central government, my lord. It is furthermore clarified there.
Yes.
The question of fixation, ultimately the rule is same, whether it comes from central government, state government, central government, PSU to central government or central government to PSU. That also I have given, my lord. The basic fundamental rule is same. The question of fixation of pay in cases of appointment from state government to central government consequent upon revision of pay scale on acceptance of recommendation of 6th Central Pay Commission in the revised pay structure has been considered in consultation with the Department of Expenditure, and the President is pleased to decide that in the cases of appointment of state government employees in central government on or after 1/1/2006, pay will be fixed in the following manner. Where the state government has revised the pay scale of their employees in the pattern of 6th Central Pay Commission at the base index of 115.76 as per AICPI IW 2001 series with effect from 1/1/2006, the pay of these state government employees on their appointment under the central government would be fixed as follows. When the appointment is to a post carrying higher grade pay, my lord, here also he came from 49 to 5900. He is getting a higher grade pay. One increment equal to 3% of the sum of the pay in the existing grade pay will be computed. 3% of the sum of the pay in the existing pay. Existing pay, his existing pay is, my lord, 12660 plus 4200. Grade pay is 4200 and his existing pay is 12660. Computed and rounded off to the next multiple of 10. This will then be added to the existing pay in the pay band. That rounded off figure, that is here, my lord, 505, that will be added to the existing pay, that is 12660 plus 505. The grade pay corresponding to the higher post will thereafter be granted in addition to this pay in the pay band. The grade pay corresponding to the higher post, that is 5900, that will be added to this, my lord, the total comes, that is 13170. In case where the appointment involves change in pay band also, the same methodology will be followed. However, if the pay in the pay band after adding the increment is less than the minimum of the higher pay band to which appointment is taking place, pay in the pay band will be stepped up to such minimum. We are not very much concerned with this later 3-4 lines, my lord. We are concerned up to, my lord,
So we will be followed.
Band. Just prior to in cases when the appointment to a post carrying higher grade pay, one increment equal to 3% of the sum total of pay in the existing grade pay will be computed and rounded off to the next multiple of 10. This will then be added to the existing pay in the pay band. The grade pay corresponding to the higher post will thereafter be granted in addition to this pay in the pay band. My lord, this is the situation in state FRSR also and FR 22-1A1. He'll get the increment, and as per ROP rule 2010, increment is 3%, and he'll get the grade pay of the higher post. That is the benefit he is entitled. He is not entitled to fixation of his my lord pay, which the perhaps Honorable High Court registry that at that point of time has wrongly done. He is not entitled to 11,875. That later on that will further be revised as per the ROP rule of 2010 by using the fitment table and giving him 22,000 basic pay plus the grade pay 27,900. So rule is absolutely clear, and that is precisely has been done in his case, and that's how this my lord correct position, that is 19070, has come.
So according to you, instead of 11811, instead of 11 when he was appointed,
Lordships.
assuming that instead of 11825, he would be getting 19070. This is your case.
No, Lordship will for a moment forget this 11825. It's not required for us now. That was an interim arrangement made before coming of the that is what has been corrected by the government. This 11825 that was given to him, that was not that was not supported by any law.
No, what we are saying is that, see, that was an interim pay scale. When the post was advertised, when was the post advertised?
Post was advertised
2008, man.
2008.
2008.
This pay scale which was prescribed in the advertisement,
Yes.
was it an interim pay scale?
No.
No.
That was a pre-revised pay scale.
Correct.
That was a pre-revised pay scale.
And revision happened when? Which year?
revision happened with effect from, Milord, it came on 2010.
2010,
22/1/2010.
22/1 to 2010.
2010.
Before that, that the post carried that pay scale.
Yes.
Now, whatever it is, if the revision, though revision has taken from 2010, suppose the government does not implement it, or does not implements it after 2-3 years, whatever it is. Therefore, till the new pay scale is revised, till the pay scale is revised in terms of the new ROP, here is 2010. Till then, those who are working, they will get certain pay scale. You can't say that pay scale is all provisional.
No, that is what
What is provisional pay scale? You cannot have you cannot advertise a post on the basis of provision. You said that the pay scale which was advertised, which was along with advertised, what is advertisement?
11.
Annexure 1, my
Page
lord. Page 38.
Page 38. Page 30. Now this pay scale in pay scale, Guwahati in the pay scale of 5275 so and so, so and so, so and so. Is it a fixed pay scale? It was a regular fixed pay scale. There was no doubt. It is not a interim pay scale.
No.
Now, in 2008, assuming that in May it was advertised, he is appointed in June 2008. What scale he will get? What is the pay scale he will get? Forget about Assam revision.
Milord, I'll simplify.
No, because see, let us go sequence wise, time-wise, timeline.
I have understood.
Don't mix up your 2011, then give retrospective effect, dimming. Let us forget about it. Let us do that later on. On 23rd of May, this post was advertised, giving certain pay scale. Let us assume that he gets appointed in 30th May. Because that, assuming that everything goes on very fast pace, everything is okay. He's given appointment, he joins on 30th of May 2008. What is the pay scale you will offer to him?
There where the problem is.
What problem?
Lordship will appreciate. For a moment, let us, Milord, I'll just put it in this way. Let us have a more simplified situation, Milord.
No, let us see, Mr. Das.
I have understood your
situation. Let us not bring all those together.
No.
From now till the filing of the case, till the filing of the complaints, anonymous complaint, forget it.
No, nothing.
Let us see one by one. 23rd May 2008 advertised.
Yes.
Let us assume that the process is over within 2 days. We use computerized process to AI and everything. You are selected. 30th May he joins. He has to pay some. In that appointment order, what will the pay scale you will prescribe? Forget this, because the ROP
pay scale will be this.
same. Okay.
But basic pay.
Again, basic pay.
Yes.
Forget this 2010. Let us not bother about 2010. Then when then according to you, he will get 18.
He will get
18.
11. No, Milord.
Then you will get, according to you have worked out the grade pay is.
Lordship,
You have worked at 19070. 19070. He'll get 1970.
1970.
Is the pay here?
No.
Yes. Pay protection, pay in the new post after pay protection. You are according to your calculation 19070. You'll give him, which is beyond this pay scale prescribed under the advertisement.
This 19070 or Lord, sorry, that's 16860. This figure came to us after implementation of the ROP in the CBI.
Oh, again you are CBI.
No, Milord. This has significance. That is why I'm just trying to satisfy.
Then what is it? On what?
Lordship will have a more simplified situation.
Yes.
Lordship will consider that there is no pay revision.
Yes.
No 10 CPC, no ROP rule 2008, no ROP rule 2010.
No. You cannot see. I'm telling you again. Time frame sequence wise. Time. Let us go by minute, day to day. Calendar. You cannot say that let us assume 6 schedule is not, because he was already enjoying 6 pay scale when he was in CBI.
Fine, my lord.
You cannot deny that.
My lord.
You cannot assume that let us not apply.
Lordship wants yes, my lord.
So suppose he had not applied, he would be on 23rd of May when the post was advertised.
Yes.
he was already serving in CBI. He
Yes,
was getting some pay scale. What was the pay scale on 23rd May 2008? What was the pay scale?
23rd May.
2008. He had not yet joined.
He was getting 5,500, 9,000.
5,000.
5,500, 9,000.
And okay. And this 2008. Okay. Then in the meantime,
Then he's,
you took your time.
in 2008, I'm just telling your lordships.
Then
his basic pay
then
would be-
Mr. Singh.
I'm sorry.
Mr. Das. Now, we'll come to that.
Yes.
Now 2008. At that time, this AC AC was, see, by that time he was this revised CCS RP 2008 had been implemented 2006. 2006 have been implemented.
Yes.
So he will be getting 9,300 so and so with GP.
34,000.
Yes.
34,000, huh?
Yes. 9,300, that's 34,800 plus grade pay 4,200.
Now he joined on 10th of
9/1/2009.
2009.
Yes, ma'am.
Okay.
9-1.
9-1. Sorry, 9-1. He's on 9-1. Now, when he joined,
Yes.
when was the result announced?
My lord, I was appointed, my lord, on 26th of December 2008. Annexure 2, my lord, page 41.
You are appointed on 26th of
26th December 2008, my lord.
26th December
2008.
joined the High Court, huh?
No,
Appointed.
appointed, my lord. Joined on 9/1/2009.
Appointed in the High Court. When he was appointed in the High Court, he was still serving in CBI.
CBI.
Okay. Now, till he leaves, technically resigns, he is entitled to certain pay scale,
Yes.
certain pay. Till then, what would be the pay scale in CBI?
His last pay was 16,860.
16,860. So he'll be entitled to the
Yes.
16,860.
Protection of this
Protection pay scale.
16,860.
But unfortunately, when he joined on 9/1/2009, that pay scale was not available
Not
in Guwahati High Court. Therefore, he had to be given the minimum, which is, you have advertised, that
Decision
is
was taken that yes.
11,825.
Since his pay is 16,860, which is much higher than the.
Therefore, he'll get
so-
this 11,825.
11,825.
So when he joined on 9/1/2009, he was getting 11,825. Correct?
Yes, my lord.
That is a pay scale he will be entitled to. Correct?
Yes, my lord. As a stop gap.
as a-
That was decided, in fact. It's on record, my lord.
Again,
I'm
stopgap.
sorry.
Which is the stopgap again? Which is the stopgap arrangement? Is the pay scale which is mentioned 5,275 is a stopgap? Are you saying that? Then
I'm not saying
forget
the
the
pay
stopgap.
scale is stopgap. I'm saying the basic pay given to him, that is 11,825. Lordship has seen the office note wherein it is said that subject to my lord clarification from the government, this was given to him.
Oh, again, Mr.
Lordship will, my lord, complete the query, my lord. I'll address
Yeah, yeah.
Lordship's query. I'm sorry.
See, when it was advertised, the maximum was 11,825.
My lord.
This pay scale, which had mentioned in the advertisement, is it final or it is a stopgap? Itself is a stopgap.
Pay scale is not stopgap. my lord.
Ah. If it is not stopgap, if it is final, at that time, once he is appointed on 9/1/2009, he joined. And so far, till then, 9/1/2009, there was no revision in the pay scale.
No.
Okay. Once he joined, he enters Guwahati High Court. Once he sits in the courtroom, start taking dictation, he will be entitled to some pay. What is the pay you will give to him before the revision of pay?
That,
What will be the-
that was 11,825 was given to him.
11,825?
Yes. my lord.
11,825. Now he takes 11,825. Then there is a revision of pay. All evidence, "Arey, have you got the revision?" Other, after in the tea break, other stenos come and, I have received this revision 2010. Hoy gol more. Hey, to me, paise naki. Then I said, I will also apply. Then revision from what to what? Then when it will be revised at 2010, in 2010, revision will be from which pay scale to which pay scale? You tell us then. From which pay scale it will be revised?
Revision will be.
Revision
from
has to be from an existing pay scale.
5,725.
Is it 5725 or
dash 11
11825? When you say, therefore, if you say that no, in the revision, it will be calculated on the basis of 5725. Is it your case? Though he was already doing 11825. Now, when the revision takes place,
Lordship will kindly appreciate one thing. In between, my lord, I'm just,
yes,
I'm sorry, my
no,
lord.
no problem. I'm trying to understand. Don't worry.
I'm
Because see, these are new to me also. I'm not very
Yes.
good. I told you I don't
have
know how
also-
to calculate.
I have also tried.
I don't know how I passed my mathematics, but I did pass in first div also. Maybe the examiner, he must be sleeping, giving array first division de do karo. Sometimes it happens also. No, examiners sometimes they fall asleep. Just like you see, sometimes people say, I don't know, it is correct or not. Say that judges also sleep after second now while listening lengthy argument. I don't know whether it is correct or not. People say. So sleeping is something, it happens to everybody. The examiner also can sleep. So he must have slept. That's why he gave me first division in maths. But I don't know maths, I'm telling you.
That did not happen with your lordships, my lord. That's 100%.
You're certain of that, Lordship.
That is not a good joke, my lord.
So please tell me, which is that pay scale from which the revision will take place? Revision means from an existing
pay
scale, then it will be revised.
to a next higher pay scale.
So let us forget how much it is entitled as per the revised pay scale. Let us go later on. But what is the pay scale from which the revision will be given? That is what I want to know.
Yes. The my lord, pre-revised pay scale of this 5725 11825 was revised to the next higher pay band and grade pay, that is 12,000 dash 40,000.
Okay. So this which is the pay scale which is given in advertisement was revised to 12,000 to 40,000. When it was revised?
It came into effect from 1/1/2006 also in the state of Assam.
So everybody who was enjoying this earlier pay scale of 5725 to 11825, their pay scale will be also correspondingly increased.
Revised.
So then in that case, since he was enjoying 11825, what will be the revised pay scale then?
That is the wrong that has been done. That
You mean to say that he will not get revision?
No, he'll get revision.
Then from
Prior to revision, he is entitled to pay protection.
so he is getting pay protection, no?
His pay protection will
Correct.
come.
No. Are you going to say that when he joined, he will be given? You say that as per pay protection, he will be 19070. That means when he joins service in Guwahati High Court, he will start getting 19070. Is it your case?
No,
Then?
that has to be protected. But because he will be a loser if he joins in 19870. So that has to be protected in terms of FR 22-1.
Okay, we'll hear again. 3 o'clock. We'll continue hearing.
My lord.
Monday.
Monday. Thursday, my lord. If otherwise.
No, not Thursday, because single, only either Monday or Wednesday.
Lordship.
Monday or Wednesday.
I'll just check, my lord. Bear with me. Wednesday, my lord. Wednesday.
You go hard, Mr. Swencho. Since the matter relates to revision of pay, obviously, revision of pay, and since the issue involves dispute in the revised pay scale, revised pay scale, obviously, it will be necessary to understand what is the pay which is being revised. First, it is to be ascertained first what is the pay which is being revised. If the petitioner, if the dispute is about revision of pay after joining the High Court, the High Court may, the respondents may clearly indicate what was the pay scale which he was enjoying on the date he joined service in High Court. And what is the revised and what will be the revised pay scale after implementation of
The
Assam
Assam Services Revision of Pay Rules 2010.
210. Since the petitioner had joined service in the Guwahati High Court before the aforesaid ROP of 2010, he was being given salary on the basis of certain pay scale. That may be clearly indicated so that we can understand indicated in other case, in any subsequent revision which may take place in the present case, which was in 2010, the revision has to be given on the existing pay, just a pay scale which the petitioner was enjoying just before the implementation of the 2010 ROP. This perhaps we want to know. Then after everything, how much, Mr. Das, kindly, because see, he joined in 2009.
I understand.
At that time, ROP has not come into picture. So he must be getting some pay scale.
Yes, ma'am.
What is the pay scale? Then 2010 ROP comes. Then he gets his salary, whatever pay scale he is enjoying, it gets revised. How much he will get in the revised, that is not the issue here. Because unless we understand what is that, because here the problem is that you are showing something else. That is the whole confusion this court is getting. I mean,
I'll clarify.
that please clarify,
Yes.
because I want to know what is on, that is, when it was given effect in 2010?
22/1/2010.
That ROP at 210, which was given effect with effect from 22?
It came into force on 22/1/2010.
22/1/2010. Therefore, it will be necessary to understand the pay scale pay scale which the petitioner enjoying on 21st of 10,
21st January.
21st January
2010.
2010.
It came into effect from, order was issued, notification came on 21, but it was given effective from 2006. So perhaps this query, my lord, last query, my lord, that on 2210, what will be his thing? That, my lord, because retrospective implementation.
Well, that is covered by Rule 12 of the ROP Rules 2010.
He is placing his story.
No, that is exactly the.
But it relate back, my lord.
Yes, correct.
So whatever has happened, go back.
Because you are because 2006, because it is given effect with from 2006.
1/1/2006.
But then 1/1/2006, assuming you are already in service in Assam, no?
Yes, right.
In 2006, he was not in Assam.
No, man, no.
He was in central government, CBI. Though the revision of pay scale ROP provides that it will be given with effect from 1/1/2006. So I have now, so you tell us then,
Yes,
because that is what little bit this court want to know.
my lord. I'll you know, satisfy a lot.
But
This 1/1/2006,
my lord,
but that this 6 we also 1/1/2006,
My
which we already enjoyed.
my lord, this one, my case is covered by Rule 12. Rule 12 of the Assam ROP.
What does it say? Rule
Yes, my lord. They are on a wrong premise that it is covered by Rule 11. Rule 12 says fixation of pay in the revised pay structure subsequent to the first day of January 2006. Where a government employee continues to draw his pay in an existing scale and is brought over to the revised pay structure from a date later than the 1st of January 2006. My case, my lord. His pay from the later date in the revised pay structure shall be fixed by adding the basic pay applicable on the later date, 9/1/2009. The DNS pay applicable on that date and the pre-revised DNS allowance based on rates applicable as on 1/1/2006. This figure will be rounded off to the next multiple of ₹10 and will then become the pay in the
Okay.
applicable pay.
एक काम करो, this will not be typed in order sheet.
My lord.
Huh?
My.
Because this is a tentative view also,
My.
because they are part of, don't write this, hard so and so, list the matter again on direct review. But this you can give, this is what
Yes,
it is
my.
occurring in my mind, I just want to give you for your
My
thought, huh?
Otherwise, I have taken note.
Okay, very well.
Otherwise, provisions are there in section.
But then kindly see, Mr. Nair has said as FR 11.
My lord.
FR 11 covers his case.
Rule 12, he is referring.
Rule 12 of
They say of the ROP.
ROP, huh?
This which is not fine.
Rule 5.
Spell. Well, I will go.
If
So
it-
at the very section, Lordship has made a pointed query to me.
Yes.
So how, my lord, that sixth pay commission of the central government is applicable?
Okay,
This is now, my lord, how it comes. my
okay,
lord.
very well.
Yeah, my lord. We will clarify.
Yes.
I'm so.
The whole problem has arisen because of this retrospective effect, no?
Yes.
And this changing taking
We
place.
will clarify.
One more sitting, Lordship will be clear.
And a double benefit. This concept of double benefit, if it is there, tell me, because I don't know.
No, if we go by the submission of the petitioner, Rule 12, relying on Rule 12, then there is no question of pay protection and all these things, not required, my lord.
Okay.
All are obsolete. Then FR 22-182 is vanished.
No, but then whatever it is, whether you call pay protection or debt protection or double benefit, he is entitled to certain pay scale. Huh? So how do you work it out? Whatever nomenclature you give.
I'll place some better calculation before your lordship.
Okay, very well. Okay.
Ultimately, my lord, the matter will boil down, my lord, as to the fixation of pay.
Correct.
When on the day, my lord, as fallen from my lord's mouth,
Yes.
he was sitting and he was started taking dictation.
Yes.
What would be the fixation of pay?
Yes.
That's it.
Yes.
Yes.